All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
All right, good morning, everyone. We apologize for the slight delay this morning. We had some technical issues on our end getting started. Thanks for your patience. Welcome to the District of Columbia Court of Appeals for our virtual oral arguments today. We'll hear two cases this morning. The first case is Andre Harvey versus United States. I'd like to welcome to our panel Judge Phyllis Thompson in her new status as a senior judge on this court, and one of our newest judges, Judge John Howard, for his first oral argument since joining the court. Counsel, are you ready to proceed?
Yes, Your Honor.
Okay, all right. You can proceed, Ms. Soltis.
Thank you, Your Honor. Good morning. May it please the court, Deborah Soltis on behalf of appellant Andre Harvey. Mr. Harvey comes before this court.
Did you want to reserve a few minutes for rebuttal? I'm sorry to interrupt you, Ms. Harvey.
Yes, thank you, Your Honor. I will reserve 3 minutes for rebuttal. Thank you very much.
Right.
Mr. Harvey is challenging his convictions for armed carjacking, robbery while armed, and 2 counts of PFCV, each of which is rooted in an out-of-court, uncertain, tentative, equivocal, purported ID that was made by the victim of the carjacking, Ryan Jordan. Admission of this out-of-court identification at trial violated Mr. Harvey's due process rights, principles of evidence, and requires reversal of these convictions. In addition, Mr. Harvey's reliance on the out-of-court identification and the overall identification at trial was insufficient to support these carjacking-related convictions as a matter of law.
Ms. Soltis, can I jump in and just ask you a little more about the concerns you raised regarding the out-of-court identification, the photo array? I'm not clear on where you're focusing your argument, whether it is on the suggestivity prong, and if so, tell us why, and where you stand with respect to the reliability, given the fact that the victim was in such close contact with the appellant for the time that they were in the car, just a few feet, if that much, away from each other, where there was arguably a good amount of time to observe is assailant.
Yes, Your Honor. There are 3 challenges to the admission of this ID testimony. There is a due process violation here, Your Honor. In addition, there was no positive ID itself ever made, as the video reveals. Fortunately, this was video. And thirdly, as an evidentiary matter, the out-of-court identification lacked reliability. I can turn first to the due process argument which the court has raised. Your Honor, Detective Ghali made repeated urging and pressure on Mr. Jordan to make this ID, despite the clear uncertainty that Mr. Jordan was expressing palpably. At the very start of the ID proceeding, Mr. Harvey quickly looks at the top 6 of the 9 photos. It is a 9-photo array ID.
He very quickly focuses in on 2.
Exactly, Your Honor.
7, number 9.
Exactly, 7 and 9. And Mr. Harvey repeats several times. The video is only 4 minutes long. The government has I know already submitted it, and I'm sure the court has already watched it. But just briefly, Your Honor, Mr. Jordan goes back and forth several times between the 2 photos, saying it's one of these 2. It's one of these 2. Clear ambivalence. Detective Ghali tells him he seems to be having, quote, a strong reaction to one of the photos. She urges him, Detective Ghali urges Mr. Jordan to, quote, go with his first choice, like he did when he was little on a multiple choice test. She says this is, quote, the advice she would give him. She urges him, in essence, to ignore his palpable equivocation between photos 7 and 9 and give his best guess, like a kid does on a multiple choice test. Mr. Jordan continues to go back and forth, makes no choice, and then says, I think it's this one, and puts some marking of a circle on photo 7. He hands it to Detective Ghali. But moments later, just moments later, Detective Ghali turns to him and says, how confident are you in your selection? And to this, Mr. Jordan shakes his head in the negative direction like this. And he, on his own accord, grabs that photo array back from Detective Ghali and continues to go back and forth between photos 7 and 9, indicating clearly that despite the circle, he remains uncertain. In his trial
Ms.
testimony,
Otis, I take all your points, but to me, the really interesting thing here is that the jury saw this video, correct?
yes, they did, Your Honor.
And does the record show that they were able to also hear the video? They could hear what was being said?
It appears that the jury could see and hear what was happening.
I asked because I watched it myself and I actually couldn't hear, but I don't know whether that was my equipment or whether the jury could hear or not. And does the record also confirm that the jury received a copy of the photo array during deliberation, so they had that?
Yes, Your Honor, that was an exhibit.
All right, well then what's your response to this point, which is that it just seems to me that seeing all that transpired, his certainty or lack thereof, his reaction to the detective's comment about going with his gut, the similarity, if any, between the individuals shown in number 7 and number 9. I mean, the jury got to see and hear and consider all of that and take into account whether this identification really was a positive identification or whether it was a questionable one. So how do you show prejudice on this record, even if your points have some merit? And they have some merit. They have some merit for sure. There was encouragement to go with your gut, and I don't know what kind of a standard that is, but there was some encouragement. But does it matter on this record?
It absolutely does, Your Honor, because we don't give unreliable identifications to the jury and let them figure it out. We have a due process standard for reliability as well as an evidentiary standard for reliability. We entrust our trial courts to be the gatekeepers here. And this trial court utterly failed at its job. In fact, based on the record, the trial court clearly misapprehended its obligation to review the underlying out-of-court identification as well as the testimony at trial and determine its reliability. That's the trial court's job, not the jury. And when the trial court clearly misapprehended its obligation, it stated
Well, now when you say the trial court clearly misapprehended its obligation, I'm not sure where I see that in the record. I think that the trial court seemed to clearly understand the question of whether or not this was suggestive, and then also discuss the reliability of the identification as well. So that's different. The conclusions that the trial judge reached may be different from the conclusion that perhaps would have been more favorable to the appellant. But how does that show that the trial court didn't understand or comprehend its obligation?
Your Honor, when the defense counsel at the close of Mr. Jordan's trial testimony renewed its motion to suppress, which included all arguments, including the due process argument, as well as reliability as an evidentiary standard under Beatty and Sheffield. The trial court's response, and this is in our opening brief as well as our reply, was that the motions court had already determined suggestivity so that any findings regarding reliability would not affect admissibility. That is a misstatement of the law. Beatty and Sheffield clearly obligate the trial court, when an objection is made, to review the out-of-court identification for its reliability as an evidentiary matter. So first and foremost, the trial court, when I say it misapprehended its obligation, it thought the deal was done, that this ID was coming in regardless of any finding regarding reliability, and that is inaccurate. Secondly, Your Honor, at the conclusion of the trial, oddly, after the government's closing, the trial court sua sponte returned to make some reliability findings, saying that it meant to circle back to something it had left dangling. Even at that point, Your Honor, again, the trial court was, from its own words, only doing the quote belts and suspenders work related to the due process suggestivity finding made by the motions court. The trial court clearly, again, did not make any findings of reliability as an evidentiary matter that could have blocked the
Counsel,
implementation of this idea.
help me on this point too. Your opposing counsel brings up, the government brings up in its brief that the evidentiary objection wasn't specifically raised at trial. Can you point and show me to where we should find that so that it's even preserved here on appeal?
Yes, Your Honor. I'll find the site if the court gives me a moment. The defense counsel, at the close of Mr. Jordan's testimony, says to the trial court that it is renewing its motion to suppress. The trial court responds saying, and we're at transcript 1015 at 95. The trial court says, you brought out all of that about probative value, and that's all for the fact finder at this point. The trial court clearly understood that defense counsel was raising an issue regarding probative value of the identification testimony and misstated the law, which was that this was all for the jury to decide whether or not the ID was reliable enough to have its probative value outweigh its prejudicial impact. And that's at 95. The trial court also states that, excuse me, court's indulgence. Also states that the trial court, that the motions court ruling on the suggestivity was the end of the decision, and that any findings regarding reliability would not affect admissibility. And that's all at 95. So while the government, perhaps doesn't see enough for its purposes, that it would like to see defense counsel arguing more specifically about the evidentiary basis by renewing its motion to suppress, which is in our appendix at A and C, that those motions to suppress that had been filed clearly raise reliability as an evidentiary matter. But the trial court cut off defense counsel. It's hardly fair to use that against the appellant at this point. That the trial court stated its opinion that probative value was not for the trial court to determine at this point, but rather was for the jury. And that we believe preserves the issue for this court's review.
Well, if we go back to the question of the overall question of reliability, the trial court does make mention of the DNA evidence that also corroborated the out of court and then in court identification of appellant. There is this issue of the distinctive feature of the appellant is chipped tooth, as well as other facial characteristics from which appellant was able to make the identification in the photo array and again in court. which seemed to lend reliability to the opportunity that Mr. Jordan had to observe his assailant. When you look at that with, in combination with the other evidence, seems to me that all of that would lend additional credence to the reliability of his ability to make this identification.
Your Honor, the trial court misapplied the Biggers factors for reliability, and in addition, applied them in a way that didn't make any sense. As we argue in our brief, in this case, where there are alternate suspects identified by a victim, it doesn't make sense. And the Second Circuit has recognized it. And we reference the rationale of Solomon, a case from the Second Circuit, about how Biggers factors.
Solomon to me is factually distinguishable from our case here in some key ways. I mean, in Solomon, two separate distinct identifications were made. Here, we only had one identification made of suspect number 7 in the photo array. And, to me, that calls in, further bolsters the fact that arguably Mr. Jordan was being thoughtful as opposed to indecisive about his identification before ultimately honing in on a single suspect, unlike the Solomon case where 2 different conflicting identifications were made.
Your Honor, Solomon may have involved 2 different proceedings, but it involved at its root the same idea, which is a victim who says it might be suspect A or it might be suspect B, and how the Biggers factors, particularly 1, 2, and 5, which had to do with degree of attention, opportunity to observe, and lag of time between the incident and the actual ID, how those factors don't really tell us anything when a witness is stuck between 2 suspects. In this case, Mr. Jordan, while it was only 1 ID proceeding, is clearly stuck between 7 and 9. And Your Honor, you may say it means that he was being careful, but according to his own trial testimony, he agreed that even after he circled photo number 7, he was uncertain. Not
Did he
careful.
ever identify suspect number 9? I don't recall that from the transcript. He never said, "Oh, it's 9. Oh, no, it's 7." He said, "I am focused on these 2," and then he ultimately only identifies number 7 as he makes his ultimate decision. Am I wrong about that? Did he ever say it's 9?
He says it's one of these 2 several times, Your Honor. And even after he circles 7, which is what I assume Your Honor is referring to as his identification of 7, he takes back the paper and again points back and forth. He doesn't say the words, it's one of these 2, but by pointing back and forth, he's clearly indicating that he is still stuck in that same space where he can't decide between 7 and 9. So while Your Honor, he never identified 9,
Well,
he
counsel,
never identified 7 either, other than that circle.
counsel, he circled number 7, which was the way to identify. And what do we make of the fact, as the chief raised earlier, that they weren't smiling or otherwise showing their teeth? So that distinctive factor wasn't there. And in the record, we can see that Judge Edelman made the finding that the photos of 7 and 9 were substantially similar.
If we're looking at factor, whether or not Mr. Jordan's description of his assailant as, Biggers factor number 3, when we look at that factor and we look at how the trial court looked at that factor, the trial court looked at it improperly. First of all, the trial court said that it was only the height that Mr. Jordan had gotten wrong. And the height was a big difference, Your Honor. When we look at the description that had been provided by Mr. Jordan said he was about my height, which was 5'11". The record shows that Mr. Harvey was 6'4" or 6'5". That's almost a foot of difference.
But they were seated. They were seated in an automobile for the time. For
Not
the,
initially. Oh, sorry, Your Honor. Sorry.
Okay.
Not initially, Your Honor. No, they were not. They were at a 7-Eleven outside talking extensively, according to the trial court, before they get in that car. They're standing.
right, but the photo of, I mean, in the time that they're riding in the automobile, they're seated next to each other, and then the photo array, well, I mean, I take your point about the height discrepancy, but I wonder whether the other factors of the length of time being seated side by side in the car might impact or perhaps weigh even heavier in the process of the identification.
Oh, it would, Your Honor, if he had been certain on whether it was 7 or 9. But if you look at the amount of time he spent with him and you look at his equivocation between 7 and 9, that amount of time isn't relevant in the way it typically is relevant. And that's Solomon's point. Solomon's point is that when a witness can't decide between two suspects or shows, a leaning toward more than one suspect, that the amount of time they spend with their assailant isn't a determinative factor, so that we look at two factors really much more heavily. And those two factors are the third and fourth factors. One is the description, and two is the certainty. Let's start with the certainty. There was none throughout the ID proceeding, even after he circles number 7. He is uncertain. He indicates it, and more than that, he testifies at trial under oath that after he circled number 7, the reason he took back the photo array and kept going back and forth is because he was uncertain. The trial court says that the degree of certainty is difficult to ascertain. That's not true. That's not supported by this record. It is easy to ascertain. There was none. When we turn to factor 3 under Biggers, the description, it's a mixed bag. It's inconclusive. On the one hand, yes, he's got a missing tooth. That is distinctive. And Mr. Jordan does report that his assailant had a missing tooth. And according to the trial court record, Mr. Harvey does in fact have a missing tooth. On the other hand, the height difference is so profound that his description on the height difference goes the opposite way of his description of the missing tooth. In addition, there's a dark-skinned, light-skinned allegation that is made and is raised by trial counsel. Mr. Jordan describes his assailant as dark-skinned. And according to the trial court record, Mr. Jordan is darker skinned than Mr. Harvey is. So there is some question about a description of a dark-skinned assailant here being reliable. Factor 3 under Biggers, based on that confluence of matching on the missing tooth, clearly not matching on height, arguably not matching on skin tone, makes factor 3 indeterminate. But factor 4 certainty clearly weighs against reliability. The other factors, given that Mr. Jordan was stuck between two assailants and two suspects during the photo array, simply do not weigh as heavily. And that's the rationale of Solomon. While Solomon is not identical, it raises the same concern. And so this court should not defer to the trial court's finding of reliability for several reasons. One is that the trial court misapprehended the import and the impact of its reliability findings, believing that it wouldn't affect admissibility at all. That's inaccurate. It's easy to find an abuse of discretion when a trial court misstates the law to that degree. Secondly, the trial court does not apply the Biggers factors in any way that commonsensically addresses the uncertainty of this particular ID proceeding. And 3, in applying the Biggers factors, the trial court mischaracterizes the underlying record on factors 3 and 4. And for those reasons.
I was going to say, counsel, I see we're already over time, but just briefly, if you could. So if we take it arguendo that you're right and this should be suppressed and it's not even there, what do we do with all the other evidence? I mean, the standard of review, as I researched it, says that we have to look at this in the light most favorable to the succeeding party below, and we have to find, if we want to overturn these convictions, that your client, there is no way a reasonable jury could have found him guilty beyond a reasonable doubt. And so we have an in-court identification, we have DNA evidence, we have fingerprints, we have a kind of a mass of other evidence that, if we're reading it in the way that the standard review directs us to, as opposed to strongly in the favor of your client, how do we get where you want us to go?
Well, Your Honor, there are two different ways. On the challenges to the admission of the ID, that's a different, that would be a different standard. We're really looking at whether or not there was either constitutional error or harmless error here, and whether or not the impact of an out-of-court ID that the government hammered on during its closing and in its rebuttal, focusing, as it always does, on the fact that that out-of-court ID was made just weeks, I believe it's 3 weeks after the carjacking. And the evidentiary punch that kind of out-of-court ID makes on a jury has been well recognized by this court, compared to an in-court ID, where a witness just points across to counsel, to the defense table, and says, that's the guy. A year later, there's real concern that out-of-court identification was relied on extensively, as the government urged the jury to do. And yes, there is other evidence here, but none of the other evidence attaches directly to the allegations of the carjacking. And what I mean by that, Your Honor, is there is external fingerprint evidence on the outside of the car. There is DNA evidence found on the passenger side of the car. The DNA evidence supports that Mr. Harvey had contact with this vehicle. That is true. But the vehicle,
Uber driver who missed some of this.
I'm sorry, Your Honor, you broke up for a second.
I was going to ask what you make of the testimony of the Uber driver who witnessed some of the events related to the carjacking.
Yes, Your Honor. Well, I think it confirms that the carjacking occurred, but I don't think that it goes any distance in making the identification of Mr. Harvey any more reliable than it is, which is not reliable. There's nothing from the Uber driver that I recall that would address the uncertainty of Mr. Jordan himself. Clearly, the Uber driver doesn't make an ID. And so it doesn't address that at all. And,
all right. I was going to say we had used up your time with many. I know you reserved some time for a rebuttal. Unless there are any points you haven't yet made, I'd like to hear from the government. Anything further, Ms. Soltis, before we hear from the government?
Your Honor, the only other thing I would briefly address is that when this court looks at identification testimony as sufficient to support a conviction, I think it's really telling in cases like in ASH that when a witness says, I was 70 to 80% certain of my ID, that this court says that's not enough as a matter of law. And this court goes with the math and says 20 to 30% possibility of doubt is not enough. In this case, Mr. Jordan went back and forth. Do the math, that's 50% reliability, 50% certainty. This court has looked at identifications that were more certain.
That same day, that's the way. Because going back and forth and then saying and circling one of two that you've narrowed down from a total of, I think, 9, if I recall correctly. That doesn't necessarily, in my mind, equal 50%. It equals a sort of a narrowing process to come to a conclusion. But I know we've been around on that one, so we'll give you a chance on rebuttal to further respond.
Thank you, Your Honor.
Thank you. Ms. Park?
May it please the court, Ann Park on behalf of the United States. The motions court did not err in denying appellant's motion to suppress identification here, and both the motion court and the trial court, contrary to appellant's assertions, well understood the law on identifications, applied it correctly, and all their factual findings were well supported by the record. Appellant continuously says that, appellant's counsel continuously says that the complainant here was stuck between two suspects, or two plausible suspects, and that simply is not reflected in the record. As Chief Judge Blackburn-Rigsby noted, he selected, and the trial and the motions court found, he circled number 7. It's clear he made an identification. He narrowed it down to 2 quickly. He circled number 7. He said, I think it's this one. The dispute between the parties comes after that point, when Detective Galley asked how confident he was. It's clear Mr. Jordan does not answer that question verbally. However, the motions court, Judge Knowles, she actually asked to view that portion of the video again, from how confident are you on. She reviewed it again, and she made a specific factual finding of fact that was reasonable based on what she saw. And she found that when the detective asked, how confident are you? Mr. Jordan was clearly agitated. He was very upset. He was breathing heavily. He picked up the paper. He went between 7, 9, 7. She found that he flinched at 7 and seemed to confirm his selection. Not so much in words, but by his emotional response and by his demeanor and his conduct. And certainly that is a reasonable inference to be drawn from the record. And as Judge Howard pointed out, all inferences are to be drawn in the government's favor. And that was certainly a reasonable conclusion that Judge Knowles could make after reviewing the video and listening to Detective Galley's testimony very carefully. He selected number 7. And the level of certainty, although appellant's counsel continues to say that he was not sure, he was definitely sure because he testified to it at trial. And the record does reflect at the very end of the cross-examination, defense counsel was able to elicit that he was not sure, but that was after about the 3rd time asking. If you look at October 15th, 19 transcript on pages 85 to 86, defense counsel is cross-examining Mr. Jordan about how sure he was because he kept going back and forth between 7, and he kept trying to get Mr. Jordan to say it's because he was not sure at that point, even though he had circled number 7. And Mr. Jordan responded, no, by that time, I realized that it was him because I got emotional and it was like reliving. Found the pictures are similar and he was just making sure. Judge Knowles then found that he flinched at number 7. He pounded his fist, and that for her was a confirmation. Furthermore, at no point did Mr. Jordan ever say it was number 9, as appellant's counsel seems to suggest. He never scribbled out number 7. He never said, oh, I made a mistake, either at the procedure or at trial. So the government would submit that based on this record, Judge Knowles's findings, as well as Judge Edelman's findings regarding reliability, had substantial basis on the record, and they're supported by Mr. Jordan's trial court testimony. The other portion of the trial court testimony that I'd like to point out is his in-court identification. And that also goes to the level of certainty as to his selection of appellant. After Mr. Jordan identified appellant in court as the person who took his car, the prosecutor asked appellant to stand and display his teeth. And the prosecutor then asked Mr. Jordan whether he had the opportunity to see appellant's front teeth. And Mr. Jordan said yes. The prosecutor's next question indicates that Mr. Jordan had paused before saying yes, and the prosecutor asked Mr. Jordan to explain why he paused. And Mr. Jordan stated, this is like reliving this all over again. The prosecutor asked, do you remember seeing the teeth? And he says yes. So he has the same emotional response in court when he sees appellant's teeth and the most distinctive feature, as well as emotional response when he sees a photo and he concludes that number 7 was a person who took his car at gunpoint. He's having the same emotional response. That is certainly a level of certainty that is beyond even words can say. His body is literally responding to seeing the person in court who committed this crime on him. So for all these reasons, at the end of the day, regardless of whether the procedure was suggestive or not, the reliability of this identification was very strong. And Judge Edelman went through the vigorous factors, and there does not seem to be any dispute that the three of the factors are strongly in the government's favor. Mr. Jordan had ample opportunity to observe appellant in the car several feet away while he was seated in the front passenger seat. Mr. Jordan testified that 5 to 8 minutes passed and they were driving in the car before he even noticed the gun, which would have caused him some stress and anxiety. His description of Mr. Harvey included the most distinctive feature, which is his most missing tooth, which he could have easily seen as he was talking to him. All these, and then the level of certainty, although it is harder to assess in the sense that there was no verbal articulation of it. Nevertheless, the record indicates that there was a level of certainty, and Mr. Jordan testified in court that he was sure and he was just reliving the experience.
Counsel, can you talk about the description a little bit more? That there was a missing or chipped tooth is definitely descriptive. There's a significant portion of the population that may suffer from that same, I won't call it an ailment, but same feature. But the height was, well, I wouldn't say a foot of difference, more like a
half a foot,
6 inch of difference or so. I'm concerned about that. And I'm not sure that I take the point about complexion, especially since we're looking at nighttime versus daytime and in photos and elsewhere. Seriously, but what about the other features? Presumably they talked for a period of time at the 7-Eleven before getting into the car. And part of the reason that Mr. Harvey even ended up in the car was because of potential appearance of him and Mr. Jordan's assessment of that.
Yes.
How should we deal with the description being so vague and the points that your opposing counsel raised there?
Your Honor, well, the description that Mr. Jordan gave on the body worn camera footage that is a part of the record on appeal, the government supplemented, he actually didn't talk about the height. When I looked at it again, he said black male, black or blue jeans, black or blue jean jacket. A distinctive feature that he remembered was his tooth missing right in the front. He didn't have a mask on. He had a beard and he had a haircut, which I infer means like a short haircut. There's actually no height description. At trial, he testified that he was about my height, 5 foot 11 inches. And there may have been reference to his height and maybe other descriptions he gave to the police. But in any event, it was a general description. But the most distinctive feature, and a missing front tooth, although other people definitely have it, is not common, is what he recalled distinctively. And when he was looking at the pictures, he quickly ruled out the top 6 and zeroed in on 7 and 9. And that seems to me to show that he had a recollection of appellant's facial features, because he had the opportunity to carefully observe them. His height, although appellant's counsel makes much ado about it, I think at the end of the day, the discrepancy is not that he recalls Mr. Harvey being tall, 6 foot tall, 6 feet tall, about his height. It's not as though the defendant's 5'4" and then his mother comes in court and testifies he's 6'4". There's not a foot of difference. It's easy for people to say 6 feet, around 6 feet, 6'4". The differential doesn't seem to me that drastic. In any event, if you look at all the other factors, opportunity to observe, attention to detail, the 3-week period, the level of certainty, if you view the record the way Judge Knowles did, that he was certain about his identification based on his emotional response, the accuracy of the description, the fact that the tooth was gone, it's the most important feature. And also in the photo array, the complainant obviously couldn't see the teeth. So the most important distinctive feature was missing, yet he still, based on his ability to recall the details of appellant's face was able to select Mr. Harvey.
Does
And
that go both ways, Ms. Park? The fact that what Mr. Jordan recalled as the most distinctive feature was the missing tooth, but that was not really a factor. It was not visible in any of the people in the lineup. No smile, nothing as a basis for the identification. Does that bolster the argument of appellant that it really came down to a guessing game between 7 and 9, particularly given that they were very similar as the record indicates?
I think the fact that the photos did not display the teeth maybe explains Mr. Jordan's hesitancy or any uncertainty or the careful way he was looking at the pictures to make sure that he had the right person, because the most distinctive feature was not apparent. So he was taking even greater care to make sure that the person he selected was a person that he recalled from that night. I think that's the way it cuts. I think that's the way Judge Edelman, he noted it when he was talking about level of certainty. In the government's estimation, it heightens the reliability of his identification, because even without it, he took time and the care to make sure he had the right person.
Ms. Park, Ms. Soltis emphasizes that Judge Knowles incorrectly articulated the standard for admissibility. Do you concede that she did that?
No, Your Honor, not at all. And I don't know if Your Honor is referring to Ms. Soltis's evidentiary argument that Judge Edelman, I think it was Judge Edelman, she was saying only was looking at it on due process grounds and wasn't considering that he had to look at reliability as an evidentiary matter. So if the identification was so lacking in reliability, it couldn't be admissible. It would not be probative.
I may be misremembering her point. I thought her point was about Judge Knowles, and she was talking about the relationship between admissibility and reliability. I perhaps am misunderstanding her point. But in any event, your view is that there was no incorrect articulation of the standard?
No, not at all. Both Judge Edelman and Judge Knowles clearly understood the law on identification, which is pretty basic. It's either unduly suggestive, and even if it's unduly suggestive, if it's still admissible, if it's nonetheless reliable, and you look at the biggest factors. I think what Ms. Soltis was referring to, and I'd like to clarify the record as to that, is the October 15th, 19th transcript on pages 94 to 95. When defense counsel was renewed, after Mr. Jordan had testified, defense counsel renewed his objection to the motion to suppress. So he said, I wanted to renew the motion to suppress based on his, and I think he's referring to Mr. Jordan's testimony and what he understood the detective was suggesting. And I believe if you look several pages earlier, what defense counsel at this point is referring to on page 84 is Mr. Jordan's testimony, where defense counsel was asking him about detective's questions about him, the detective trying to encourage him. And you were still going back and forth, and the officer was trying to encourage you. Well, the officer is saying, choose one of the photos, correct? Right. And that's what you took it as you needed to choose one of the photos, correct? She wanted me to identify who I had the occurrence with. So he was referring to that specific testimony that he was able to elicit on cross. And my reading, and it's not clear, defense counsel's objection is not clear, but my understanding of the record, when you read pages 94 to 95, is defense counsel was asking Judge Edelman to reconsider Judge Knowles's finding on undue suggestivity based on Mr. Jordan's trial testimony at trial. And he was saying, it was my understanding that Judge Knowles said, depending on how the complainant testifies, that I could renew my motion to suppress identification on suggestivity grounds. At that point, Judge Edelman says, My understanding about Judge Knowles's ruling was that what was left for me to make was further findings regarding the second set of factors in the analysis. So he tries to explain, if you look at Judge Knowles's ruling, she denies the motion to suppress on due process grounds based on undue suggestivity. And that ends the Fifth Amendment analysis. And that's clearly black letter law. The court in Hilton said that courts don't even need to go find reliability if they find no undue suggestivity. That ends Fifth Amendment analysis of identifications. But what he's doing now, what Judge Knowles tasked him to do was a belt and suspenders task. That is, this court in its cases has advised trial courts to make findings of reliability at trial after the witness testifies, because in the event that this case goes on appeal and gets reversed on suggestivity grounds, this court would not have to remand to the trial court to make reliability findings. So he's going to go ahead and make reliability findings on due process grounds to complete the belt and suspenders task, even though Judge Knowles already denied the motion. So this is what Judge Edelman is explaining, and his explanation of the law is spot on. There's absolutely nothing wrong with it. Appellant contends that Mr. Defense Counsel's objection here was he was making an evidentiary objection. That is, regardless of the motion to suppress identification, this out-of-court identification was so unreliable that as a matter of evidentiary law, it's not probative, it's extremely prejudicial to put in, and this court should exclude it. The problem is, if you look at what Judge Edelman was telling defense counsel, he did not understand defense counsel to be making an evidentiary objection. Had he explained it more clearly, I think Judge Edelman would have said, that's fine, I had to make reliability findings anyway. I find it's reliable as a matter of evidentiary law because its factors are essentially the same. But it was not explained to him on those terms. And if you look at Mr. Hairston's objection, if you look at it carefully, if he's not very clear about what he's arguing, but if you look at the entire record and what Judge Knowles informed him at the pretrial ruling, that is the government's understanding of the record. So the evidentiary objections were never made at trial. Mr. Hairston's or defense counsel objection was solely to renew or reconsider the suggestivity findings, which Judge Edelman said, I'm not at liberty to do, and I am going to go make reliability findings, which he did. In any event, I think at the end of the day, whether it's sufficiency, due process identification, or evidence, the reliability of an identification based on evidentiary grounds, they all look at the same exact factors. Length of time to observe, stress and anxiety upon the victim, on the witness, the length of time between the incident and the identification, level of certainty. These are all the same factors. And Judge Edelman's finding of reliability was correct, and it clearly understood the law, and especially the three factors that Ms. Soltis doesn't want this court to look at and relying on Solomon are extremely, extremely strong. And if you look at level of certainty viewed through at the record, viewed in the way that Judge Knowles did and in favor of the government, certainly his level of certainty was strong as well, based on all the evidence, the totality of the circumstances. And sufficiency, I just wanted to make one point in response to Judge Howard's question. If the out-of-court identification were thrown out, you still have the in-court identification. And we would suggest very strong evidence linking appellant to the carjacking, which is fingerprint evidence on the outside of the car and DNA evidence on the inside of the car. But I would just note that when you're looking at sufficiency of the evidence, you have to look at all the evidence that the jury had before it, regardless of whether it's inadmissible, this court deems it inadmissible or not. And that's Nelson v. Lockhart. And so you would have to look at the out-of-court identification, the in-court identification, all the evidence. The government would submit that given the reliability of the in-court identification, that alone is sufficient to sustain the conviction. But on top of that, you have the fingerprint and DNA evidence. And if you also consider the out-of-court ID, the evidence was more than amply sufficient to uphold his convictions.
Counsel, there's one more point I'd like you to respond to that the appellant took a stance on in response to Judge Thompson's original question, since we were talking about the jury recently, that the jury got to see the video, got to see the photo arrays, there was extensive cross-examination of both Mr. Jordan and the detective that was there in the procedure, and appellant took a strong stance that, well, it's a gatekeeping function. The jury shouldn't have seen it to start with. That doesn't get rid of the prejudice. That may, in fact, increase the prejudice. What stance does the government take on that?
Your Honor, I think this court's cases make very clear that it is the jury's prerogative to decide internal conflicts in testimony. Once it is motion to suppress identification is certainly a gatekeeping function, but that doesn't mean that the evidence is clean and that everything is for one side or the other. Evidence comes in, as Mr. Jordan's testimony shows. At one point he said, no, I believe I was confirming the identification because I was having an emotional response, but defense counsel was able skillfully to elicit at the end when he asked again, okay, I'm not sure. Those are all things. Both those statements of Mr. Jordan are in the record. It is the jury's job at that point to figure out, well, when he said this, is that what he really meant? Like, to credit which parts of his testimony. That's their job. Everything was put in. The motions court applied the vigorous factors correctly, as did the trial court. The motions court applied the law on identification testimony correctly, as did the trial court. It was admissible, and at the end of the day, it's the jury's job to kind of parse through it and decide what to credit and not to credit. And Bamaduro, Napper, those are all cases that government cites in its brief that talk about the jury's prerogative to make those decisions.
All right, thank you, Ms. Park. Ms. Soltis, you served a couple of minutes for rebuttal.
Thank you, Your Honor. First, to start with the government's last point, that's not the law. This court has made clear that the trial court is obligated to go beyond a due process analysis under Beatty and Sheffield's line of cases and to determine if an ID is reliable. It all comes down to reliability. That is a basis to keep out an out-of-court ID. The trial court didn't articulate its knowledge of that power or obligation. Secondly, to be clear, when I was talking about a misapprehension of the standard, I was referring to the trial court. To the trial court's statements that now that the motions court had already decided there was no suggestivity, that was the end of the game. There was no further ruling required that would have affected admissibility. That is a misstatement of the law, plain and clear. Beatty and Sheffield make that clear. Third, I agree with the government that the factors of reliability, ultimately, it is a core of what we need to look at here. What I disagree with the government about is that there's a common sense application of those factors, and that we have a video here. We have a video which shows uncertainty. We have a video that shows uncertainty after the fact of a circle of photo number 7. We have a trial court who stated that uncertainty was difficult to assess. That is belied by that video. It is further belied by Mr. Jordan's on the stand testimony. The government, like the motions court, wants this court to affirm a reliable ID here based on some ambiguous emotive reaction on that ID preceding video. It is ambiguous. There is not a single case that the government has cited, nor that I could find, that said that the trial court is supposed to interpret silent, nonverbal, emotive identification in finding an ID. There is just as much on that video that indicates that Mr. Jordan was stuck. He was stuck before he circled 7. He was stuck after he circled 7.
An assessment of whether that video shows uncertainty, what is that? Is that a factual determination? Is it a legal determination?
It would be both, Your Honor. I mean, there would be ultimately a de novo decision that this court would need to make about whether or not the ID satisfied the reliability factors. There are factual determinations that were made by the trial court in looking at that.
Yeah, I'm not
video.
really asking about reliability right now. I was reacting to your strong statement that the video shows uncertainty. And my initial reaction was, well, I'm not sure it does. It shows a victim taking care to try to be correct. It shows deliberation. Obviously it shows some hand movements of going back and forth. I'm not sure whether it shows uncertainty, and that's what prompted my question. Not an analysis of reliability, but whether that's a factual or a legal determination.
Yeah, well, it's a fact. It's a factual record. It is each of the biggest factors is a factual determination. But Your Honor, 2 points about the video. You just stated that it doesn't indicate a lack of certainty. When Mr. Jordan is asked point blank, how certain are you? He is silent and he shakes his head negatively. Look, when you watch the video, you see that. Secondly, I will point out the government never once at trial tried to shore up his certainty. I don't know why, but they never asked him, how certain are you of that out-of-court ID or of your in-court ID even? Perhaps they knew better, Your Honor, but they never
Well, some
asked
of
him.
that is why, in my first question to you, it was about the video and the jury's ability to both see and hear the video, because it really does seem to invite a jury assessment of what are you looking at here? What are you seeing when you see this man shaking his head and going back and forth and giving the other reactions that he gave? It seems to me quite valuable to have that, and it seems to me to invite some reassessment of some of the factors that go into the reliability of an identification.
Your Honor, that's a dangerous job to leave to the jury. And that's not what this court has stated in the past.
Well, there's so many dangerous things, but the ubiquity of videos is causing us to rethink many things where we used to have to rely on just testimony, or where the jury had to rely on just that. So just an observation, not a conclusion.
Your Honor,
I'm sorry, you had a few points you were trying to make. Please continue.
Your Honor, I would think, Your Honor, the government, seems to try to demean Mr. Jordan's testimony at trial because it came out on cross that he was uncertain after he circled number 7. And that's why he grabbed that paper of the photo array back from Detective Ghali. We believe in cross-examination as a way of getting to the truth. That statement by him should not be diminished in value, and in fact, it should be enhanced because.
Well, counsel, I didn't have to ask you, what do we make of his statement? Because he was asked that 3 times. One statement that, I was reliving it. Another statement that, that was over a year ago. I don't remember. Before finally at the end of being asked several times, and perhaps the government should have objected and asked and answered already. That was when he finally conceded to the point he was being pushed on.
What led him to finally concede that he was uncertain after he circled it was a watching of the video, because defense counsel says to him, you just saw that on the video. And when confronted with the black and white image of his own uncertainty, Mr. Jordan has no choice but to say that he remained uncertain. I think it was an admission that was obviously supported by the video itself. And because that video existed, Mr. Jordan wasn't able to push off the responses of, oh, that was a year ago. Oh, maybe I was just being careful. When faced with his own action, his silence in the face of the question about his certainty, he had no choice but to state the truth. And the truth is what is obviously supported by the video itself, is that at the end of the day, that day with Detective Ghali, Mr. Jordan remained uncertain. So ultimately what we had here was a jury that was told by the government in opening, in closing, in testimony from several officers Mr. Jordan himself, he ID'd Mr. Harvey 3 weeks after this incident occurred in a 9-person photo array. And when you look at the video, that didn't happen. Yes, he circled at one point, but his actions after that circling belied any certain identification. So instead, a jury, which, by the way, acquitted Mr. Harvey on multiple other charges that were before it, a jury that was trying to be careful here. And while the government may paint this as an overwhelming case, the fact of the mixed verdict certainly doesn't support this overwhelming case that the government says it had. A jury with that ID evidence being characterized as an out-of-court ID, a jury who doesn't know due process law, a jury that doesn't know what is and is not a usual way of indicating a positive ID, is left, of course, to rely heavily on that. If we pull out that out-of-court ID, we cannot say with any assurance that Mr. Harvey would have been convicted of these carjacking-related offenses. And for those reasons, and for the other reasons that are articulated in our opening brief and in our reply brief, Mr. Harvey would ask that his convictions for armed carjacking and 2 counts of PFCV and the robbery while armed, all related to Mr. Jordan, would be reversed. In the alternative, he would ask that, based on the sufficiency of the evidence argument that we've articulated, that those convictions be vacated. Thank you.
Thank you, Ms. Soltis. I'd like to thank both counsel and for your briefs and your arguments today. And we'll take this matter under advisement, and you're free to exit our virtual courtroom at this time.
Thank you, Your Honors.
Thank you, Your Honors.
All right, good morning. This is our second case and final case today. Morgan Banks et al. Versus David Hoffman et al. Joining me on the panel this morning are our now senior judge, Phyllis Thompson, and our one of our 2 new active judges, Judge John Howard, who's sitting today for his first oral argument with the court. And I believe Judge Howard has a brief statement he wanted to make at this time on the record.
Thank you, Chief. I do. I wanted to put a matter on the record at the outset of this argument in full disclosure for the benefit of all the parties as I took this under consideration. My wife was an associate at Aaron Fox over 2 years ago, at least at some point when the firm was representing one of the parties in this case in the matter below. She has not been a part of the firm in over 2 years. She did not work on the case, has never worked for the client, and has not worked for the client since then at her new firm, did not garner any confidential information about the case, and had no interest in the case as she was an associate. I considered this and don't see a basis for recusal and will be impartial. However, I wanted to put this on the record at the outset in full disclosure for the parties.
All right, thank you, Judge Howard. Are the parties ready to proceed at this time? And if so, inform the court as to how you'd like to divide up the time for argument today.
I think we've agreed 5 minutes each, and that the district would go last. And I think the other appellees will go first. I'm not sure what order.
Yes, Chief Judge Blackburn-Rigsby, I will go first for the Sidley appellees, and then Ms. Wall will go for the American Psychological Association.
Okay, and then with respect to appellants, Ms. Forrest is the only attorney arguing on behalf of the appellants.
That's
All right.
correct, Your Honor. Thank you.
All right, Ms. Forrest, are you ready to proceed?
I am, Your Honor. Thank you. Good morning, Your Honors, and may it please the court. My name is Bonnie Forrest. I represent the plaintiffs. I ask permission to reserve 3 minutes for rebuttal.
All
The
right.
Hoffman report forever tarnished the reputations of 3 respected psychologists, leading to worldwide front page headlines falsely vilifying them as psychologists who greenlighted torture. Through 7 years of litigation, defendants did not argue that the Hoffman's report's allegations were true. Instead, the motions now on appeal before you, they argued only that they published these falsehoods without actual malice and that they did not republish the statements. At the heart of this case is a bevy of factual disputes, but the trial court improperly swept those all away, usurping the jury's role as a finder of fact. I'd like to spend my time today primarily on 2 fact-laden issues. First,
Well, could you start, if you would, Ms. Forrest, by framing the legal standard under a special motion to dismiss within the context of the SLAPP statute, as we call it.
so the standard is summary judgment, Your Honor. That's very clear from competitive enterprise versus Mann. I'm sorry, Your Honor, was there an additional question on that? Or was I not answering what you're asking? I'm reading your facial expression and it looks like there's an additional question. So I want to make sure I answer your question.
I guess I was wondering if you wanted to expand on that any further. I think one of the things that the trial court is asked to look at when considering a lawsuit of this nature is well, there are a number of factors. Were there public officials? Has there been demonstrated a likelihood of success on the merits? And so I was hoping that you could address that legal standard in perhaps maybe a little more detail.
Of course, Your Honor. So first of all, and let's take the 2 factual laden issues, actual malice and republication. Those are jury issues. The review here is de novo, and the footnote 32 in competitive enterprise versus Mann makes the standard summary judgment, albeit with some technical differences. Substantively, the Mann court was very clear that this is a summary judgment standard. Then I think what you might be alluding to is that with respect to a defamation action, we have to show a probability of success that we can show by a clear and convincing standard, actual malice. So the burden is slightly more than a preponderance, but less than a reasonable doubt as you would encounter in a criminal matter. That's the standards that really govern what we're talking about. And I'd first like to talk about, with respect to actual malice, that's an especially fact-intensive issue. Plaintiffs presented voluminous evidence from which a reasonable jury could find, not necessarily would, that the defendants had very obvious reasons to doubt the truth of the 219 false statements we identified in the Hoffman report and the statements to the press identified in count 8. That is the standard established by Mann, not whether a judge believes we should win, but whether our case is sufficiently robust that we could win. Second, a reasonable jury could easily have concluded that the defendants republished the Hoffman report in 2018. Plaintiffs demonstrated that the defendants made substantive additions to the defamatory statements, including a 62-page extensive report repeating some of the defamations. APA's general counsel then emailed the link to the landing page to the report to an open listserv and posted a similar link on the APA's website. 3 years after their initial publications. There is no way all of that gets rejected as a matter of law.
Ms.
Time
Flores,
permitting-
remind me, please, why the republication issue implicates Sidley. I'm sure your brief told me this, but it implicates the American Psychological Association because it was its website where this was reposted. Why does it implicate the other appellee?
Because Sidley, it was foreseeable that APA would republish it, and that's what the law says makes them liable. But also on the issue of actual malice, we had filed a precipice in July that said, do not republish it, take it down. Hoffman had been rehired to redo the report. If you republish this, this is a republication. They file a motion, Your Honor, that says, file a motion if you don't like it. So it's evidence of actual malice. If you double down, after you have evidence it's false, that can become evidence of actual malice in addition to being liable for the publication, Your Honor. Time permitting, I will spend a moment on the threshold question of whether these mid-rank military psychologists are public officials, even though they did not have the substantial responsibility for.
Some people might argue that a colonel, a military colonel, is not a mid-rank military officer, but rather a senior military officer. But I know you're going to expand on that further.
But I want to go there now, Your Honor, because it's on your mind. So let's go there for a moment. First of all, there's confusion over what their ranks really were. If you look at their moving papers, they call them lieutenant colonels, and then they call them colonels. Ranks really aren't important in this context. They lend some credibility, but it's really about what were your duties and what you were doing.
Rank in the military is very important. And but whether you're talking about lieutenant colonels, colonels, generals, those are all senior, at least in my understanding of military rank and operation, senior people.
So generals, I'd agree with you.
Senior commissioned officers in the military.
Thank you, Your Honor. So generals, senior people, they were in charge. They gave the orders. They tell our folks to go draft the policies for the general's approval. And that's the substantial control that the generals had, that the case law really talks about that. I'll get there, Your Honor. Let me give you that teaser and go on to actual malice. I'd like to spend some time on that and then go. We disagree that they have the requisite substantial control or responsibility that this court requires, and that they meet the three-part test that this court set out in Moss v. Stockard, which we think is similar to Castle.
In discussing actual malice, would you identify for us, please, what you think are the best examples of the court not looking at the evidence in the light most favorable to your clients?
I will do that, Your Honor. I want to give you a little bit of context first.
That's fine.
Starting with Exhibit A, JA 1302, if the court has the documents, I'm going to be dealing with statement number 17 with respect to sleep deprivation. And we identified, Judge Thompson, in Exhibit A, and the court never, in his opinion, identifies Exhibit A or Exhibit B. If you look at page 23 of the opinion, in fact, it talks about our opposition at 21. We've got Exhibit A, which attached 219 false statements plus evidence of falsity. And remembering the defendants haven't denied these are false. Their motions are filed on actual malice. We documented that these were documents in their possession that gave them very obvious reasons to know that the statements they published on 10 occasions and their statements to the press were absolutely and completely false when they made it. We're not arguing about truth. We invoked over 300 documents in Exhibit A And in corporate records backing up what we were saying about the involvement of all of the directors, including the head of the special committee. We showed that every single piece of that evidence was in Hoffman's possession, most of which was obtained from APA and in APA's possession. To emphasize, every single piece. That's more than enough to enable a jury. Let me get to sleep deprivation and the most particularly damaging statement in the Hoffman report. Now, sleep deprivation in and of itself makes up the premise for 6 or 7 statements in Exhibit A. The Hoffman report's most devastating falsehood to my clients was that the Department of Defense was using horrible torture techniques, most notably sleep deprivation and stress positions. And that plaintiffs, my clients, acting on behalf of DOD, colluded with the American Psychological Association to let those techniques continue unabated. The second paragraph of the Hoffman report summary of its findings says, quote, our investigation determined that APA officials colluded with important DOD officials. That is my clients because they were named as part of a joint enterprise between APA and DOD to have APA issue loose, high-level ethical guidelines, and this is key, that did not constrain DOD in any greater fashion than existing DOD interrogation guidelines. A few pages later, at JA 2249, if the court is able to follow the documents, the summary then goes on to state, quote, then existing DOD guidance used high-level concepts and did not prohibit techniques such as stress positions and sleep deprivation. You put those two together and you get the damning indictment and one of the most damning statements that the court never analyzed.
Well, but Ms. Forrest, the trial court appeared to carefully review the arguments in the opposition and the 34 different attachments to that, and still concluded that it did not understand how, within the scope of such a large scale investigation as was conducted for this report, omitting a comment or opinion here or there would amount to malice. In other words, the trial court seemed to acknowledge that the investigation report didn't reference every single reference in other reports that are referred to by appellants or other comments, but that didn't necessarily mean that the conclusions in their own report were patently false or made with malice. How would you respond to that?
Your Honor, I apologize. You're fading in and out a little bit. So if I talk briefly over you, I apologize. I am not trying to do that. I'm trying to wait, but you're fading in and out. I don't know if anybody else is getting that. Okay. I apologize in advance. My goal is to not talk over you, Your Honor, please.
Yeah. No, okay. I've had some issues with my audio. Can you hear me now?
I can hear you just fine now, Your Honor. Thank you. Okay.
Do I need to repeat? Should I repeat?
No, I think I got the question, but if you think I'm going in the wrong direction, you'll pull me back in, please. Okay. So I have 2 responses to that, Your Honor. First of all, if you let me work through this example on sleep deprivation, I can give you more than a few stray documents in a file drawer or an opinion. This particular one, which was so damaging, this particular statement on sleep deprivation that was so damaging to my clients, he had, and APA had, multiple documents in their hands. And it's not an opinion. This is false. DOD never approved sleep deprivation for an interrogation technique. Hoffman And Sidley and APA knew it, and they had multiple documents that smacked them in the face. And I will walk the court through that. But let me first also say 150 interviews don't matter if you don't ask the key questions to the key people. That's Jackson versus City of Columbus. There, the charge was somebody impregnated a sex worker, did a bunch of interviews, looks really great, looks very pretty. There's only one problem. You didn't ask the person who was supposedly impregnating the person if they could actually have kids because he had a vasectomy. In this case, Hoffman relies on the critics' policies, which he knows are out of date, for the timeline and what they say. He never asked the military. And more importantly, he refuses several times, if you look at the Donovan affidavit, to give her the questions so she can get clearance. He tells her those policies aren't relevant, and then proceeds to say in the document what the policies say. So let me tell you the 3 ways he had, Your Honor, to know that the defendants possessed and reviewed documents, knowing this conclusion's false. And then I'll go in, I'm not going to list all of it because quite frankly, there's quite a few documents, but I'm going to give you a sense of the documents he had that make this not about an opinion or a stray document. First, as I said, DOD absolutely prohibited sleep deprivation. There's no question. It was never an approved technique. So that statement that sleep deprivation was allowed by DOD existing interrogations, absolutely false. Second, the plaintiff's orders were to prevent abusive interrogations. To do that at the direction of the generals, they were requested to draft for approval local standard operating procedures, or SOPs, if we call them. They were even more restrictive in preventing abuses, including sleep deprivation, than overall DOD guidelines. DOD was arguing at this time, and until 2006, a year after Penn's, whether the Geneva Conventions even applied. The local policies were more restrictive than DOD guidance. That's not an opinion.
Well,
That's
Ms.
fact.
Morris,
Yeah.
so I take your argument about some of the factual discrepancies, and my colleagues may have some other fact-based questions. If I could, I'd like to turn your attention to the second and third argument about first about the district's home rule statute and your contention that the anti-SLAPP legislation and regulation in DC conflicts with home rule in certain regards.
Happily, Your Honor, I'll go to HRA. If there are no more questions, I'd like to, at some point, get back to listing at least 20 or 30 documents that are Mr. Hoffman and APA's possession that showed him that absolutely this was false. It smacked him in the face, but I'll turn for you. What I'm hearing is you'd like me to turn to the HRA now.
I would, and I don't want to speak for my colleague to make factual.
Well,
questions.
I want to hear about that other argument too, but if you could try to, as quickly as possible, finish this line of discussion, I would appreciate hearing that as well. Is that okay, Chief? I'd like to hear about a couple of the documents that you say smack them in the face.
Yeah, I as well would like some of the specifics.
Thank you, Your Honors. I'll go through the rest of this and then turn to the HRA before I hit republication, if that's what I'm hearing a consensus about from Your Honors. Thank you. So beyond the orders and the standard operating procedures, APA guidelines statement 4. So this is within APA's possession. And Hoffman cites portions of this statement and then omits the key portions. Psychologists involved in national security related activities follow all applicable rules and regulations that govern their rules. Over the course of the recent United States military presence in locations such as Afghanistan, Iraq, and Cuba, such rules and regulations have been significantly developed and refined. Psychologists have an ethical responsibility to be informed of, familiar with, and follow the most recent applicable rules and regulations. Once you look at that, you say, what are those policies or rules or regulations? You're going to see all the evidence, and I'm going to walk you through 5 pieces quickly pursuant to Judge Thompson's request. You can see all the evidence that the judge didn't analyze at J 1239 through 51, 1364 to 1442. He didn't analyze any of this. What little evidence he did analyze, he weighed and talked about the tenor of affidavits, which is absolutely impermissible under Mann. And he didn't.
Please give me those page numbers again, 1239 to 51 and what?
And 1364 to 1442, Your Honor. There's 2 charts in there on page 9 and 10 of the document. That's
Right.
actually the document of the policies, Your Honor. That's the most succinct summary. If you're short on time, I'd love to have you read all of it, but I'm certain you're busy. And that gives you the most succinct. And those are the policies that when we handed them back to APA, that's why they rehired Hoffman to fix that. And that's where
Thank
the
you.
board says there's an issue.
Please go on. Thank you.
So let me talk about 5 aspects, and then I'll allude to the others, but I don't want to pile on. First, before the investigation, APA obtained an opinion from a law firm, another law firm, Cohen Milstein, just prior to the investigation, that timeline relied on by the critics and what the policies said, they were wrong. But Mr. Hoffman endorses it anyway. And Dr. Nadine Kaslow, head of the special committee, she was APA president at the time. She absolutely knew about this. You can't stick your head in the sand. The outdated Department of Justice policies had been superseded. Hoffman uses the outdated policies anyway. Second, Hoffman had 4 copies of the standard operating procedures for interrogations at Guantanamo that plaintiffs Banks and Donovan drafted before the Penn's meetings. They specifically incorporate the Uniform Code of Military Justice and the Geneva Conventions, which absolutely take sleep deprivation and stress positions that are torture off the table. Third, plaintiff Larry James referred to the more restrictive policies on his way from the airport in an interview with Mr. Hoffman. Mr. Hoffman, he drives Mr. Hoffman to his office. He says, oh, there are policies out there. Hoffman doesn't follow up with his associate. 5 times, Mr. James, Dr. James refers to those policies. This is the APA listserv. It's on their servers still. Sidley and Hoffman admit in the report they reviewed those communications. When the Sidley team goes to Michigan to interview Dr. Bowe in his home, they were given a copy of one of those policies in a file folder. Copy has a big circle and a black pen around the date, March 2005, 3 months before Penn's. Bowe also briefed the APA board about the policy just before Hoffman's investigation began. Again, Nadine Kaslow, how in the world was she not recused, is in that meeting, sees the pile of policies that are involved, and it's passed. Fourth, Sidley interviewed a civilian interrogator at Guantanamo, Jennifer Bryson, see JA 1507. She explained that by 2004, in her interview, 2004, interrogators were required to use a computer menu of permitted interrogation techniques that did not permit techniques such as stress positions and sleep deprivation. The Martinez-Lopez report, the Schlesinger report had a chart, no sleep deprivation. The Senate Armed Service Committee report, Patrick Philbin testimony before the House Permanent Select Committee, all within their possession, all within APA's possession. This isn't just a spare document or an opinion. This is fact. Are all these omissions or documents that contradict Mr. Hoffman's conclusions random and inadvertent? From someone as smart as Hoffman with a team of 8 people in 8 months, a jury could, and remember that's the standard here under Mann, find Hoffman was too smart to have missed all this inadvertently, and instead had very obvious reasons from the documents in his possession and the documents APA had in their possession. This evidence needs to be in front of a jury. So Judge Thompson, to go back and tie up with a bit of a bow your question, he didn't analyze any of that evidence. He refers to page 21. He failed to analyze any of the evidence against APA, except with respect to the republication. He doesn't analyze the defamation by implication claim at all, and they don't even move on it in their motions. This case on that issue and the word sleep deprivation alone needs to be reversed and remanded. Now, pursuant to your request, Chief Judge, I'm going to skip over republication unless Judge Thompson or Judge Howard, unless you have any additional questions on what I just presented. I'd like to go on to the HRA.
Can I just quickly ask you if you can answer this quickly? What if you had not been limited by the targeted discovery rule in the anti-SLAPP statute and by the judge's, I guess, sua sponte reversal of his discovery order with respect to depositions, what else would you have sought to discover that you weren't able to discover?
So Mr. Free was also involved in that case, involved in the case at that time. And we filed pursuant to the 56 rule. We used to call it Rule 56E. I'm going to show my age here in a moment. But it used to be the old 56D declaration, their 56D declarations. Right. You filed to Judge Thompson. And so we were really clear. We wanted all the interview notes, right? And I think His Honor, and this goes quite frankly to the issue of Home Rule Act and why this needs to be a procedure in the rules. He didn't understand the standard. Mr. Hentoff, my friend, tells him the standard is 12B6. And I say, no, the standard is summary judgment per man. I say that at JA 878. He says, are you telling me this is summary judgment? And I say, yes. At 899, he said, well, the witness notes are, I ask him, he tells me I can only have certain witness notes if I've already have their affidavits. Well, I think he doesn't understand the standard then, because I have to proffer evidence which shows my allegations are correct. So I need more evidence. And so I go back and he said, no, that's going to be cumulative, Ms. Forrest, at 899. And I wanted all the interview notes from all the witness interviews. I wanted at least those 3 depositions. There was a question about whether we wanted a 4th from Dr. Jennifer Kelly, and we went back and forth. And you know, those would be the key interviews. It's targeted discovery. And so it was ambiguous. I didn't want to ask for the world, Judge Thompson. Ideally, I'd have 5 or more, but I was trying to go in as narrowly as possible. I didn't ask for all that I really wanted. But in here, in this case, state of mind is fact laden. And so that's the problem with the summary judgment standard on this. I get to exhaust discovery. It's not just what I think of in the moment or what is targeted. And that's why this act is so problematic and why it modifies the federal rules. So
and I know you want to get there, but let me ask you this. Your brief asserts that the DC anti-SLAPP statute is the most onerous among jurisdictions' anti-SLAPP statutes. What would you point to that makes it the most onerous?
Because I think, you know, and I come to you this morning from California, being a California licensed attorney. And so I'm pretty familiar with the California standard. California is probably second or a close second. Part of the issue is the definition, the initial definition of what it applies to. So you've got advocacy on a public issue. Because that hasn't been interpreted yet, Judge Thompson, that's being, I see the decisions of this court somewhat limiting it, but because it hasn't been limited, right now, it's all over the place. So for example, in California, we've been litigating these statutes for 20 some years. It's a question still about whether a newspaper is a public forum, because some people say because you can't have a wide open debate, that's not. Because some people say you can, and you can write a letter to the editor, It is. So you don't have any of that certainty of the statute in DC. And so if you're trying to represent somebody, how do you make a decision about what to bring when you can end up paying somebody's attorney's fees? So that makes it even more onerous because of the risk. And the initial definition that makes it apply to any act of advocacy or any public issue typically, right? It's a very low threshold. A lot of states are more narrow and they say it only applies to these sorts of actions or these sorts of actions. You've got California on this extreme, Judge Thompson, and then on the other extreme, you have statutes that are limited to, for example, environmental actions because of the type of issue that the DC government has now sought an exemption for, because the statutes were being misused in environmental actions by large corporations. So that's the basis for my statement about the breadth of it, Your Honor. Turning to the HRA, I really believe it's pretty simple. The statute is void and unconstitutional. The act creates new procedures, even if you think there's some substantive aspect to it that aren't in the federal rules of civil procedure. This court is the arbiter of the rules of the rules that govern the Superior Court if there's a modification. This court didn't approve these procedures as required by Congress and 11-946. The statute is invalid. That's simple.
When you say this court didn't approve these procedures, are you talking about this court's function to review changes or additions, revisions to the DC Superior Court rules?
I'm talking, I'm going to read something into your question, Your Honor, which maybe I shouldn't do, but I think you may be alluding to, did Mann approve it? But I'm saying no. I'm saying yes to your question, which is this court didn't approve a modification to the federal rules of civil procedure, and these procedures aren't in the federal rules of civil procedure. It's that simple. Your recent order on April 4th approving modifications, if it's the case, show that there's a process this court follows. And that makes sense from a separation of powers. And also, how does this rule work? This court is uniquely suited to understand how rules impact various other rules. So how does the SLAP procedure, how does that impact discovery? How does that impact the process? So for example, in California, you have to file a separate motion for discovery. Do you have to file a motion here? Do you file a 56D affidavit? Do you file something else, right? This court, as the arbiter of the judicial function in DC, that's your role, not the DC Council. And all
Counsel,
the other cases.
If I can pause you there, help me understand, because I am definitely looking and seeing that there's some substantive right or piece here in this. Is what you're asking us to do to invalidate the entire anti-SLAP Act? Or is it that procedures just need to be made by Superior Court who uphold the substantive right and approved by this court? Because if you're asking me to invalidate, if you're asking us to invalidate the entire act and that to have such a substantive right, this would need to originate with Superior Court and come up to us, I'm having separation of powers issues with that and us usurping the legislature's authority to create substantive rights.
So if there are procedures, those procedures are invalid. That's my first part of the answer to your question. I disagree that there are substantive portions of this. I know that's been identified in the legislative intent, but that's not what it did. The statute is procedural. The language is procedure. It created two motions that govern the process of the lawsuit throughout the system. It didn't create a new substantive right. It didn't change what I have to prove for defamation. It only expedites the summary judgment process. It flips the burden. That's why in Mann, they call it a reverse image. It flips the burden. Instead of being on the non-moving party, or sorry, on the moving party, it's on the non-moving party. It ups the ante Because instead of the defendants having to say, this is a triable issue of fact, and having a response, that process is gone. Okay, and it says attorney's fees are mandatory because that's in Doe v. Rourke what you've said. So all those things, including the burden of proof, and this court has already said, U.S. Securities versus Bruton, burden of proof is procedural. So I understand that there may have been a desire to create a substantive right, and page 10 of the DC brief said it's the right to free expression. At some other places, they say it's the right not to be tried. Well, the right to free expression, I'm not certain exactly what that is, but a Rule 12 and 56 help you implement a right not to be tried. This applies across the board in a way nobody ever imagined. It's been applied to small claims. It's been applied to employment discrimination. That's never what this legislature intended. It was based on 2 lawsuits where grassroots activists were protesting and they were sued by big developers. As the DC Attorney General has said, I couldn't have said it myself better, this statute is being abused and turned on its head by large corporations, including the defendants in this action. There is no allegation
Ms.
that this
Forrest?
is a slap.
You know, what
Can-
I'm trying to figure out, Ms. Forrest, is whether or not what the anti-SLAPP statute does is directly contrary to Section 11-946. You know, the Woodruff case tells us that. We haven't been so rigid in interpreting 11-946 unless we're looking at something that's directly contrary to what it says. And is this so? Is the thing called a special motion to dismiss in the anti-SLAPP statute directly contrary, for example, to what Federal Rule 56 calls a motion for summary judgment and what it says about a motion for summary judgment? Or is the special motion to dismiss just something extra that doesn't necessarily conflict, but is just additional? And I was trying to think of a better example. I don't have a really good example, but I was thinking about the fact that in our Superior Court, we have divisions that deal with subject matter that you would not find in the federal court. So we have a probate division, for example. We have family division. You know, people get divorces and they and they deal with custody matters. And over in probate, they deal with wills. And these are not things about which you find rules in the federal rules of civil procedure, because that is not the work of the federal courts. So is the special motion to dismiss something akin to that, you know, just something not known to the federal rules, different, but not in conflict? Or is it really in conflict? What's your answer to that? I know we've called the special motion to dismiss an expedited summary judgment motion. I think we said that in Bonner, for example. Do you understand my question? And how would you answer it if you do? I guess if you don't, I ought to ask it again, right?
Your Honor, I think I followed you, so I don't know what that says about both of us. I think good things, but I try to follow you. And again, you'll reel me back in if I didn't, okay? It conflicts, Your Honor. Let me take the analysis in component parts. Does it conflict with Title 11? And then does it conflict with the federal rules? Because I think they're slightly different. So let me address each one. Does it conflict with Title 11? You know, I think Mr. McKay's article on separation of powers, and if you look back at the historical documents that I attached to the motion below, separations of powers and checks and balances on rules are pretty important. And this court understanding and being the arbiter of its own rules is really key. And Varela versus High Power Stirrups, which was en banc, said very clearly that the congressional intent is that the federal rules of civil procedure govern the work of the DC Superior Court. And that's clear. I don't know how you get around that.
But Title 11, 946 also says that the Superior Court may adopt and enforce other rules as it may deem necessary. And it can even do that without the approval of this court if those rules don't modify the federal rules. And this gets back to Judge Thompson's question about, is this special motion to dismiss really modifying the federal rule, when earlier in your argument, when I asked about the standard of review, you said, no, it's basically the same as summary judgment. So how then does that modify the federal rules in a way that would be an actual conflict?
So that's part two of my answer, Your Honor. Thank you for going there. It modifies it in very important ways. Although if you look at, and the key again is footnote 32 of competitive enterprise versus Mann. And every court to look at this, with the exception of one federal circuit court, and that's the First Circuit, and we can talk about that in a moment, every court that looks at this has said there is some conflict. All of them have, most of them have said it completely conflicts and you got to throw it all out to get to Judge Howard's question. The Ninth Circuit has carved it up, but it's actually before the Ninth Circuit again in two cases in June, being re-argued because the Ninth Circuit decision in Newsom was actually decided prior to Shady Grove. So we're going to get another look at that. Otherwise, the First Circuit is the only circuit that says, no, this doesn't conflict. Everybody else has said this is conflict. Why? When the court in competitive enterprise versus Mann interpreted this as substantively the same, it says it's a reverse image though. The burden is flipped. In a normal Rule 56 motion under the federal rules, the moving party has the burden of identifying non-tribal, non-disputed issues of fact. Then it flips the burden. Okay, this doesn't happen in a typical summary judgment motion. Then it flips to the plaintiffs to proffer evidence to show their case. That's above and beyond a Rule 56. That at least modifies, which is the language 11946. I don't even need a conflict, but understanding that the federal courts, and while you're not bound from them, you've got a situation where you're now creating forum shopping because the federal court in DC has ruled twice that this creates a conflict. And so you've got a situation where then Judge Kavanaugh said, nah, this is way more than a Rule 56 motion. And then again, in Ta, the court revisits it after Mann and says, now you've got a higher burden on discovery here. You have to show targeted discovery. And that's exactly what you all said was the case in Friedman, that this is a higher standard than that created by 26. Judge Kavanaugh alludes to, is it a conflict with Rule 11? Because that's discretionary. This says, because of how you've interpreted it, attorney's fees are mandatory. So not only is it outside the rules, it adds a burden in several important ways that Rule 56 just doesn't do. And that's key. That's why it modifies the federal rules. The DC Superior Court, look, Peter Nichols says when this is being considered, go talk to the judiciary. I don't know whose phone rang because it's not in the statute. That's why you collaborate. The DC courts could have passed the rule after the whole rules process and then send it up to you, like that April 4th order that we attached to our supplemental authorities, passed it up to you and says, okay, let's put this out for comment. Let's think this through. That's not academic. The trial judge here is on the rules court, the rules panel. He didn't know the standard for the motion. He didn't know the standard for discovery. This is an academic, and we're talking about my clients are not wealthy people, okay? And we're talking about mandatory affirmative fees for a motion I don't know the confines of, and people who are actually in DC, Mr. Hentoff represents a 12B6 motion. So that's why it's not operating within the rules and it's not academic. And that's why this court needs to be involved and the arbiter of its own rules and about how this works through the system. Because you have a lot of people who are under this statute, subject to attorney's fees, whose rights to access this court and to have their voices heard are being cut off prematurely. That's what this court is about. That's what 11946 is about. You are the arbitrators of procedure, whether or not it attempted to create substance. Yes, Your Honor.
I am cognizant of the time. I know our questions have taken you well over your time. Did you want to briefly address the issue that we may have skipped over, which was the republishing by reposting the timeline? And I guess, as I understand, and from the exhibits in the record, the timeline is different from the landing page, where the timeline simply lists going back, 20 years or more, any publication of the APA. How is listing that as one of its many publications a republication to a different audience, which is how I understand the framework for a republication?
I will give you 2 or 3 sentences on that, Your Honor, and then if I may have 2 or 3 minutes also on public official, I would beg the indulgence of the court, if I may, just quickly. Thank you for your questions. If I could go to those 2 issues, that would be great. The trial court's opinion acknowledges on page 11, Your Honor, that a statement on a website is substantively republished when the statement itself is added to or altered, or it's written in the disjunctive, the case law has said, or you reach a new audience. Through 2 affidavits, plaintiffs demonstrated the statements were added to and it reached a new audience. You only need one of those. That republication was foreseeable to Sidley, and that's all that is required. Their brief says you have to actually be involved. That is a misstatement of the law. What in fact happens is you only have to have it be foreseeable. In answer to Judge Thompson's questions, I've addressed that. The republication at that point is an issue for a jury. The case gets reversed and remanded, and it goes back to look at that issue. JA 1815-6, JA 1821-6. Let me turn briefly, unless Ms. Chief Judge, you have any other questions on that issue, let me go to the public official, if I may, for a moment. Thank you, Your Honor. Appreciate the court's time. Defendants bear the burden to make the showing that plaintiffs are not private citizens. They failed to do that. They didn't proffer any evidence. We have 5 affidavits which document in extensive detail that plaintiffs did not have substantial responsibility or control as members of the military to significantly influence the resolution of issues of public importance. I refer you to Moss at 1229, 3-part test. Instead, their role was to draft documents called standard operating procedures that implemented the interrogation policies established by their superiors, the generals. They created those documents at the order of the generals for their approval. Nor were they able to access the media to defend themselves, nor, and this is key, have the defendants identified, they didn't even make the argument in pages 16 to 17 of their briefs, nor have defendants identified any independent interest in the qualifications of what these people were doing. Nobody even knew where psychologists were before the defamations here, what they were doing in the military. There wasn't an independent interest in their qualifications as this court required in Moss. Instead, defendants rely solely on their titles, which those aren't even right, and on a misrepresentation of language cherry picked without reference to the other language that says they were ordered to do this. The test is, here's the person in charge, here's the night watchman. Where in that hierarchy do you fall then? Do you have enough substantial control or responsibility over the affairs or influence so that if this gets debated in a public forum, you can impact the debate? Our folks didn't have it. I refer you JA 1462, JA 1540, 1655, 1648, and 1753. One of those affidavits is from a judge advocate general talking about the fact that colonels do not have the requisite authority to set policy in the military. Thank you.
Does the public official issue stand or fall in the same way as to your three clients? I mean, is there a stronger argument as to one or more of them than as to the others? That's a difficult, I realize that as their counsel, perhaps that's a difficult question to answer, but just looking at their titles and the descriptions of what they did, I had difficulty with it myself and wondered whether we need to distinguish between them.
And I agree with you, Your Honor. And the reason I'm having difficulty is because I have evidence in my head that was never in the record, because that record was never developed. So I absolutely agree with you, both on what's on the basis of in the record, what their titles were and what their roles were, which were never analyzed by the court, right? Which should have been, and what their duties were. Things like supervisory authority, budget authority. If you look at the report itself, it never talks about their titles in terms of rank. It talks some about their duties, and those aren't even all accurate. So for example, in Dr. Banks's situation, Mr. Hoffman takes a title that a journalist has wrong, and he lumps it in the report. He has him as, for example, head of SEER, which is a group of psychologists within the military. He wasn't. So that gets changed later, but that goes to show you it was sort of a stab in the dark about what they actually did. So yes, I do think there's a different analysis for each one.
And if the chief will indulge me, this one question occurs to me because of your mention of the record. I was pondering whether, I was looking at something in the appendix, which turned out to be a citation to a filing in the trial court, which had a hyperlink to something, I forget what, raising the question of whether the thing that one gets to when you click on the hyperlink is part of the record. I don't know whether that's an academic question for purposes of this or not, but do you have an answer to it? Or
I
are
don't
those
think
hyperlinked items part of the record on appeal?
Absolutely, they are, Your Honor, and I don't think it's academic. That's practicing law in this day and age. And in this case, at JA 1114, and actually, if you read JA 1111 through JA, I think it's 15, you'll see I asked several times to proffer evidence. I said, this is an evidentiary hearing. At one point, the judge absolutely agrees and says, I ain't gonna read it. I say, I need to put these documents into evidence. I have a duty to my client. He refuses to allow it. So to preserve the record, which I said to him on the record I was doing, I said, Your Honor, I have a duty to my clients, then this is what we're going to do, and I'm going to attach them. I referred to them again in the hearing, and I can give the court those sites after I sit down with rebuttal. When I stand back up, I can give you the sites. I referred to all of them in the hearing. I went through the documents again, making certain how they were relevant and talking about that, and he ultimately doesn't analyze it. So I think specifically in this case, they're part of the record because he otherwise wouldn't let me proffer all the evidence I wanted to, which, as I'm certain you know, under Rule 56 is required. I get to proffer the evidence I want. He refused to allow me to do that. I even offered 3 separate affidavits twice. I said he refused to allow me to do sir replies proactively at one point, and the defendants entered new evidence with respect to an affidavit I had 3 affidavits and I come to he says, no, sir, replies, issues an order. I show up to the hearing and I say, I have 3 affidavits. He said, how long have you had them? I said, about a week. He said, then you're not entering them. I stand back up again at the hearing and I say, my understanding this is evidentiary hearing. I proffer them and let them respond afterwards. I understand that you may think there's undue surprise. I'm putting them in again. No, I refuse to allow you, Ms. Forrest. So in this case, I think there's a special circumstance, Judge Thompson, that yes, it is part of the record because of the circumstances under which I was limited. But I also think that makes sense in electronic age. The court could say, I offered to give him, even at the hearing, hard copies of all this and to walk him through. And he didn't take me up on it. I would have preferred to have an evidentiary hearing and proffer all of these paper copy. I did the best I could to establish a record for my clients. And I think they're absolutely part of the record here.
Thanks.
All right, Ms. Forrest, I know we keep saying we're going to turn to the appellees for their argument and that we've taken you well over time with our questions, but I do have one more question, which is a follow on to the previous question I asked about your argument as to why the appellants here, in your view, are not public officials. And it seems like you're saying that it was their more senior officials who set the direction for the military policy and that your clients were merely implementing the policy. But if I think about that logically, it sounds like what you're saying is, although they were given broad policy direction and discretion to end the abusive interrogation techniques, they followed that broad directive, but they had discretion and ability and authority to create more specific policies in implementing this broader policy. And those more specific policies that were actually implemented at the discretion of your clients were what are discussed in the Hoffman report. And it seems to me that makes them public officials under the definition, at least the very first prong of Castle, which our court has explicitly adopted. And I'm not sure I see the authority that you rely on for what seems to me, and I'll play the devil's advocate to be a bit of hair splitting on what you mean by public official and what I read Castle, at least the first prong of Castle, to mean by public official.
This is the crux of the matter. How much substantial responsibility or control over policy did they have? They were ordered down to the interrogation sites to prevent abuses. Part of that, and again, I want to be clear, and this is part of my answer to Judge Thompson, part of this isn't in the record, Your Honor, so I have to be really careful, and that's why the record here needed to be developed. So I want to be clear with the court. They were ordered by the Army Surgeon General to go prevent abuses. Okay, so that's a very broad mandate. Then they get down there. General J. Hood gave the order, and you can read this in the affidavit from Jennifer Bryson, the civilian interrogator. J. Hood, and I talked to each of these generals who are very anxious to testify. They're not allowed to give affidavits. Another problem with the statute. They're very anxious to testify to tell their side of the story. They ordered local policies that were more restrictive. They send our folks off to draft the policies and put in the language that's necessary. Then that policy physically is taken back to a general, in this case, Generals Hood and General Abizaid. And you can see, again, this is in our rebuttal evidence. And Judge Thompson, I gave you those sites earlier about our evidence about the policies folks had. But Generals Hood and Abizaid then had to approve those policies. I don't believe that that's really what the Supreme Court was talking about, because if you're having a debate about the fact that what should the policy be? The generals are the ones who have the substantial control responsibility of policy, not the mid-level people writing the words, nor can they change the policy. So if you go back to the purposes of New York Times versus Sullivan and Rosenblatt and Gertz, it's about informing the electorate and informing the public about what your government officials are doing. And this wasn't the type of activity, physically drafting the policies for somebody else's approval, that the court wanted to pick up.
Well, but it was your clients, arguably, and other psychiatrists who were present during in some of the interrogations, not the generals.
That's not the evidence in the record, and that's never what was argued here. So the issue is what were the existing interrogation techniques and what did those say and what were the policies? That's if you go back to page 9 and page 12, Your Honor, he says existing DOD interrogation guidelines. He doesn't say the policies for psychologists. He doesn't say this or that. He says existing interrogation guidelines. There were no separate existing interrogation guidelines for psychologists.
No, I didn't
My
say,
client,
that's not what I said. I said the interrogations included psychologists who were present during interrogation. So they're arguably encompassed in the guidelines. Whether
I don't know that that's in the record that my clients were in interrogations, Your Honor.
No, not your clients, but psychologists were present in interrogation. And so am I correct on that? If I'm misstating that part of the record, I apologize. But my understanding is that psychologists were present during some of these interrogations that are at issue.
I think that's the allegation, but specific interrogations weren't at issue, Your Honor. And it's certainly my clients, whether they were or were not in interrogations, is never part of this record or what they did.
All right, anything further? Any other questions from my colleagues? All right, thank you, Ms. Forrest.
Thank you, Your Honors.
You've reserved some time for rebuttal as well.
Thank you.
Mr. Hentoff, I believe you were going to lead off for the appellees.
That's correct, Chief Judge Blackburn-Rigsby. Can everyone hear me okay? Thank you. Good morning, Your Honors. May it please the court. I'm Thomas Hentoff with Williams and Connolly. We represent the defendants appellees Sidley Austin LLP, Sidley Austin DC LLP, and Sidley partner David Hoffman, and I'll refer to our clients collectively as Sidley. Ms. Wall for APA and I have a division of labor. In addition to the issues we'll each be addressing relating to plaintiffs' efforts to establish actual malice as to each of our clients, I'll be handling plaintiffs' public official status and the plaintiff's challenge to the DC Anti-SLAPP Act to the extent I dip my toe into it ahead of Mr. McKay. And Ms. Wall will be handling plaintiff's republication claim as it applies to both defendants. Before I start, I'd just like to make two brief observations. The first is defamation lawsuits take a reputational toll on defendants if they're without merit. And Ms. Forrest started by saying in the course of 7 years, Sidley has never defended the truth of its report. In August of 2017, Sidley used the procedure available to it under the DC Anti-SLAPP Act for the protection of free speech and filed a special motion to dismiss based on the plaintiff's inability to establish actual malice. And that's the motion we've been litigating. That, of course, doesn't mean that Sidley concedes that anything in its report is false. It's just that it is moving only on actual malice and therefore assumes for the purpose of the motion that there's falsity that can be established. My second observation is, I would say one word that I agree with that Ms. Forrest said is voluminous. Everything about the plaintiff's litigation of this case has been voluminous, which has made it a challenge for the defendants to get the benefits of the Anti-SLAPP Act. And I think one of the most significant things that I can say about the Superior Court's careful analysis of the evidence in this case is that, and as I think it was Chief Judge Blackburn-Rigsby who mentioned it, his discussion of the 30 some odd affidavits. The Superior Court took on that great volume and saw that when you actually look at that evidence, it falls apart. There's a great volume, but very little substance. So this is an appeal that combines a highly rigorous constitutional fault standard, actual malice, with an extensive record that shows that plaintiffs proffered evidence that Sidley acted with actual malice when it submitted its independent report to its client. The proffered evidence is entirely insubstantial. And as we discuss in our briefing, this is sort of like the Talley v. Time Inc. case from the 10th Circuit that we rely upon and the Superior Court relied upon, except this is a much larger case than that. In Talley v. Time Inc., a team of Sports Illustrated journalists spent months, interviewed dozens of people, interviewed and re-interviewed people. And the 10th Circuit there said, ruling on the same summary judgment standard that's applicable here, all of these general allegations that can come up in an actual malice case, like purposeful avoidance or bias or things like that, just doesn't hold water when you see all the hard work and all the effort to learn more that went into the large investigation like that. And of course, when a team of journalists or a team of lawyers is doing an investigation and then they issue a lengthy article or report, they've got to make decisions. They've got to make judgments about all the different things that they've heard. And unbelievably, even in a 540-page single-spaced report, you can't publish everything you've heard. So in this case, Sidley's investigation was more extensive than the journalists in Talley v. Time Inc. And it was on behalf of its client who asked for an independent review of serious allegations. And it's undisputed in the record that Sidley lawyers over the course of 8 months, they didn't only interview 150 people, including all of the plaintiffs. They went back and conducted 50 follow-up interviews to get more information. And they published their findings, not just the extensive report, but APA also made public 7,000 pages of public exhibits. So, as the court has alluded to, the actual malice standard is very rigorous. It's very difficult for a public official plaintiff to satisfy. This was noted most recently by this court in an anti-SLAPP case, Friedman v. Orbis Business Intelligence. And we know that the burden on the plaintiff is to provide enough evidence to create a triable issue of fact that the defendant actually published false statements about the plaintiffs, knowing they're false, or with a high degree of awareness of probable falsity. Now, this is a subjective standard, which requires proof that the defendant, in fact, entertained serious doubts as to truth if published anyway. And then on top of that, this court in Mann said, we apply the First Amendment clear and convincing evidence standard at this stage. Now, Ms. Forrest said slightly more than negligence without citation to a case. Well, that's not the case. It's a very serious additional evidentiary standard, which the Supreme Court has described as the ultimate fact finder must have an abiding conviction that the truth of the factual contention of actual malice is highly probable. And in this extensive record, the plaintiffs have come up empty. There is no evidence that at the time Sidley published the report, its lawyers actually had serious doubts as to the truth of what they published. These are serious charges by the plaintiffs to levy against a law firm conducting an independent investigation. And the evidence is simply not there. So I'd like to address some of the points that Ms. Forrest made in argument on these issues, unless the court has a question for me before I start. Okay, so I'd like to start with public official. And Chief Judge Blackburn-Rigsby noted that, Colonel seemed like a very senior rank. And the fact is it is, but I'm sorry, let me back up just for a second. And one thing that hasn't been expressly raised, but it's important, is that the preliminary issue of the plaintiff's public official status is a question of law for the court to decide. This court said that in Thompson v. Armstrong. The Superior Court mentioned that, and plaintiffs don't challenge that, nor could they. As the Supreme Court said in Rosenblatt v. Baer, we treat it like we treat a common law privilege question in a defamation case. We decide that. And the Superior Court here decided it correctly. I think Ms. Forrest said we relied on titles and some language. That's not correct. What we and the Superior Court relied upon were extensive admissions and descriptions of the plaintiff's responsibilities and duties as they carried out their jobs as psychologists, colonels in the Army during the War on Terror, with substantial responsibility for how, for example, psychologists would go about supporting interrogations during the War on Terror. So Ms. Forrest suggested it's somehow a top-down question, and if you're not at the very top making policy, you're not a public official. But as we cited in our brief, the leading treatise says it's by no means limited to the higher echelon of governments. And frankly, we need look no further than this court's decision in 2016 in Thompson v. Armstrong. The plaintiff who this court determined as a matter of law to be a public official was a supervisory agent in the Treasury Department who supervised 5 to 7 people. And there was nothing in the record to indicate that he had a public-facing role, because that goes to the question that Rosenblatt and this court in Thompson v. Armstrong asked, which is, and just give me a moment. Well, which is, does the plaintiff have or appear to have substantial responsibility for or control over the conduct of government affairs? And so in many cases in this court, law enforcement officers, not because they're famous or are involved in a public controversy, but because they have the effect on people as members of the government that's high enough, not like everybody in the government, but they have enough responsibility so that the public has an interest in learning about their conduct. And we cited in our brief numerous cases in which plaintiffs who had responsibilities less than the very substantial responsibilities that these plaintiffs have were considered as a matter of law to be public officials. Many of them were colonels, although not simply because of their rank, but also because of their duties. And on the other side, the plaintiffs don't offer any cases in which a court agreed with them that a plaintiff with their responsibilities did not qualify as public officials. And and their own and by the way, we didn't have evidence. We did have evidence, the admissions that were in plaintiff's complaint that the Superior Court relied upon. And just to give one example that the court relied upon, as the abuses, and this is paragraph 123 of plaintiff's supplemental complaint, as the abuses at Abu Ghraib began to emerge, Colonel Banks was ordered to work with the Army's Inspector General to investigate and decide, these are their words, how to prevent future abuses. He then asked Colonel James to serve in Iraq with the role of drafting policies and instituting procedures to prevent abusive interrogations. And Colonel Donovan volunteered to play a similar role at Guantanamo. So this is broad discretion and significant responsibility, and way more than other plaintiffs who have been considered to be public officials. And that doesn't even get into the fact, which the Superior Court relied upon, that Plaintiff Banks was the director of psychological applications to the United States Army's Special Operations and Command. And he had technical oversight for all Army Special Operations psychologists. And then both Plaintiff Donovan and Plaintiff James were chiefs of the Department of Psychology at Walter Reed. And there's a lot more. I'm going to stop there. So I think that really settles that question. And I will move on from public official unless any members of the panel have any questions.
I have this question, Mr. Hentoff. I think your brief notes that this court has not employed or cited the Castle test that that pertains to access to the media. And I wonder what would be your answer to the question, why shouldn't we adopt that test? It seems like a sensible test. I have to say, I cannot remember enough of the facts of Thompson to know whether it would have been relevant there, but what is your response to that?
So the answer is no, because this is the public official test is distinguished from the public figure test, which came along later, which is very interested in all of those things about a public controversy. But as we can see from the Supreme Court's decision in Rosenblatt v. Baer, this is a test about a plaintiff's responsibility within government, period. It's not about, because the public has a right to know, it's not about the plaintiff's involvement in public affairs or public controversies. And I'd like to quote from the Supreme Court opinion in Rosenblatt v. Baer, footnote 13, which says the employee's position must be one which would invite public scrutiny and discussion of the person holding it, entirely apart from the scrutiny and discussion occasioned by the particular charges and controversy. And then finally, Judge Thompson, yes, I'll go back to Thompson v. Armstrong, and the plaintiff there did not have a public facing role. There's no evidence that the plaintiff there had particular access to the media as a spokesman or something like that. So at any rate, so the First Circuit test, which is from 1988, does not faithfully apply Supreme Court precedent or the precedent of this court, and answers a different question. And this case started out, 2 of the 5 plaintiffs, we did argue that they were public figures, and we did put a little bit of that argument. But it's a separate test, and it's always been a separate test. Is my answer to that. Okay. I'd like to move on to Ms. Forrest's discussion of the evidence of actual malice, and again, and a lot of this is her criticism of the Superior Court, who actually took on a very large task. And one of the points, as I caught it, was that Ms. Forrest talked about an exhibit. So they had, I think, 119 pages of briefing in the Superior Court on the anti-SLAPP motions. And they attached, on top of that, a chart of 60 some odd pages, which lists 219 statements and then says things about them in a column. And I think she's faulting the Superior Court for not going beyond the 119 pages and treating that as exhibit as another 60 pages. And as we say in our brief, for a party to preserve an argument on appeal, they have to develop it in some way, that's fair to the court who's examining these things. And I think it's very important that the plaintiffs didn't consider that list of 219 statements important enough to make developed argument about them in the briefs on appeal. And I went back and I looked at, and there are 130 pages of briefing in this court, and there's very little actual quoting of the report. For so much discussion about 219 separate statements, very little is quoted other than recitation of Sidley's primary conclusions, which we've fully addressed in our brief, and then this discussion of the term collusion and its definition. And this really gets us to, I guess, the core point here. When you focus on what the plaintiff has argued, it comes down to a very simple proposition that really disposes of all the arguments that Ms. Forrest said. The plaintiff's proposition is the Sidley report said something about DOD guidance, and that thing that it said is inaccurate. And here are a lot of reports and letters and things like that and policies that show that it's inaccurate. But the plaintiffs, and let me add one more thing. It is important for us all to analyze the actual statements that are being challenged, because otherwise anybody could paraphrase aspects of the report in their own words and we couldn't defend it. So I noticed that Ms. Forrest said DOD was using horrible torture techniques, and that the report was saying DOD was using horrible torture techniques, and my clients colluded with APA to let those techniques continue unabated. But the report doesn't say that these three plaintiffs were attempting to make torture continue unabated. And it's significant that the brief doesn't quote that. Ms. Forrest doesn't quote it. She didn't give the full quote. The full quote is there was collusion to make sure that the APA guidelines for psychologists didn't impose significant constraints on what the DOD was imposing for psychologists. That's an entirely different issue. That doesn't mean they were trying to torture people. So, but the main point that the plaintiffs made is Sidley made a statement about DOD guidance. And just give me one moment. But Sidley made a statement about DOD guidance. And all these different reports and policies show that it's not true. Well, to start with, I believe Ms. Forrest gave a list. She said there's 5 or 6 or 7. I'm familiar with all of those reports, but the court probably isn't, because once again, the plaintiffs didn't consider them significant enough to put them in the brief, quote the report, quote the other report, show why they're different, and then make an argument about why Sidley subjectively blew it so badly that Sidley knew that it was probably making a false statement. And the Von Kahl case, this was another Judge Kavanaugh case. The Von Kahl case said there has to be evidence of the plaintiffs, of the defendants' subjective doubt about the truth of what they're saying. It's not enough to say there was some.
Counsel, I have a question for you there. Since we're talking about the subjectivity, as I was reading the federal cases and our cases, I very much agree with you that the federal cases seem to look at the actual malice inquiry as completely subjective. But it came across to me that in some of our cases, like Burke and Mann, we had, now I'll just quote you from Burke, that we were implying that potentially the actual malice, the only part of the actual malice standard is subjective. When we said, i.e., either subjective knowledge of the statement's falsity or a reckless disregard for whether or not the statement was false. So is the standard different for us? And do you have a stance on that?
I do, Your Honor. Judge Howard, it's the same standard, because then in Howard, this court goes further, right? After talking about reckless disregard, and says the plaintiff may show that the defendant had such serious doubts. Let me read the full quote so everybody follows along. This is Mann. The reckless disregard measure requires a showing higher than mere negligence. The plaintiff must prove that the defendant in fact entertained serious doubts as to the truth of the publication. And then it goes on, the plaintiff may show that the defendant had such serious doubts about the truth of the statement inferentially by proof that the defendant had a high degree awareness of probable falsity. And I'll go further to the extent there's any ambiguity here. So I believe this court has always intended to faithfully apply Supreme Court precedent on actual malice. And the Supreme Court has said many times that this is a subjective test. Just one example is the Hart-Hanks case. So it's a subjective test. That's my position, and I'm comfortable with that. So to continue, where the fatal error or a fatal error that the plaintiffs make is they say that when on page 9, 10, or 11, the Sidley report says, okay, so APA came out with its own ethical guidelines for psychologists who support national security interrogations. And that's the Penn's task force report, right? And so Sidley concluded that an object of the collusion was to make sure that the Penn's task force report didn't tie the hands of the people in the Department of Defense who had their own guidelines for psychologists supporting interrogations, and they didn't want there to be a conflict there. And Sidley's criticism was the DoD guidelines for psychologists were loose and non-specific, and they didn't specifically prohibit things like sleep deprivation and stress positions. So in other words, the ethical guidelines for Department of Defense psychologists, which would be, if this goes against my guidelines, I've got to go out. I can't participate in this interrogation. That was the DoD guidance that Sidley was talking about. And there are two words in those pages, and there's no substitute for reading those three pages in context and then going ahead to page 229, which describes further what Sidley is talking about. And what I would say for everybody's benefit is there are two words that make this crystal clear. And those two words are virtually identical, okay? Sidley was not waving in the wind at what DoD guidance it was talking about. What it said was, and it's very simple and it's laid out in this report, plaintiff banks at the time of the Penn's task force meeting in 2005 was working on guidance for DoD psychologists. He had 2 draft chapters with him. And the Sidley report says he handed out his 2 draft chapters. It was the DoD guidance. And he proposed that this would be a good model for the Penn's task force guidelines. And what Sidley said is, in the pages that Ms. Forrest was talking about, the DoD guidance that was vague and non-specific for psychology, the DoD guidance that was vague and non-specific, that didn't talk about specifics like sleep deprivation, ended up being virtually identical to the Penn's task force guidelines. That's very specific. And we lay that out in our brief, and I think we do it in a clear way, and we cite to the record. We cite to the record right in our brief, so anybody can read the Penn's task force report and compare it to that draft guidance that Plaintiff Banks was working on. And as we say in the report, they say psychologists should work to make sure that interrogations are safe, legal, ethical, and effective. Psychologists should report abuse. And as Ms. Forrest emphasized, precept 4, statement 4 of the Penn's task force, as Ms. Forrest just emphasized, says psychologists need to become familiar with the latest rules and regulations governing interrogations, right? And so from her, so she argues, hey, through there, that means that the psychologists were in fact, that these guidelines were rigid and specific. The problem with that, and this was the criticism of other people at the Penn's task force that Sidley reported on, is if the psychologist himself or herself doesn't have a specific prohibition of participating as a psychologist, for instance, sleep deprivation, then that's not a strong enough ethical guideline for the association, because you can always just say, hey, take a look at whatever the Department of Defense is ordering for interrogators, and that's good enough for you. And I thought about an analogy to Ms. Forrest's argument, and it's sort of like the First Amendment says Congress shall make no law abridging the freedom of speech. Okay, that seems relatively clear. But if Congress instead, if the First Amendment instead said, Congress shall make sure to familiarize itself with all the most recent policies and orders regarding free speech, well, that wouldn't be a protection for free speech. So all of which is to say, the plaintiffs have failed to establish remotely that Sidley doubted that when it made its analysis of DOD guidance as compared to the Penn's task force guidance, plaintiffs totally failed to show that Sidley subjectively believed what it was saying isn't the truth. And so then we go to 20, 30, 40. It doesn't matter how many reports Ms. Forrest cites if they're all about saying that, hey, there was a policy for interrogators in Camp Delta and they were not allowed to use sleep deprivation. Or we spoke to somebody who supported interrogations in Guantanamo and they had a list of things that they could put in the computer, and the list didn't include sleep deprivation, because none of that contradicts what Sidley said. And clearly doesn't show that, oh, that indicates to me Sidley was lying about this or really thought they were wrong, but went forward anyway. So I think that shows that the volume of evidence that the plaintiffs put together doesn't go to Sidley's actual state of mind. And then on top of that, I'll go back to what I said at the beginning. This was an enormous undertaking by Sidley, in which everything that they did showed they went for more and more information. And then we apply this highly rigorous standard, in which, which this court recently in Friedman v. Orbis Business Intelligence said it's a daunting standard. Let me just make sure I get this correct. It's a daunting standard, quote, which very few public figures can meet, end quote. So that means the public official, in this case plaintiffs, they rarely win. And is this the record to buck what normally happens in these cases? No, because the evidence completely failed to show, to create a jury issue. I'd like to move on to the next issue, which I guess is republication as it applies to Sidley, unless the judges have any question for me. So I'm only focusing on Sidley because Ms. Wall will talk about this argument with regard to both defendants. But the plaintiffs make an argument in their reply brief that they didn't make in their opening brief. Initially, certainly in the Superior Court, they initially made the argument that Sidley was aware in 2018 that there could be a website change. And we made the argument, okay, if you're going to focus on Sidley's awareness in 2018, the plaintiffs didn't present any evidence that Sidley did anything after gaining that supposed awareness that there could be a website change. So under that Tabula Reyes case that we cited, which is one of the earlier Tabula Reyes case, that meant that there wasn't a publication action. So plaintiffs now say something different. Oh, no. We meant that when Sidley delivered the revised report in September of 2015, it was foreseeable to Sidley that 3 years later, there could be website changes that someone would argue was a republication. So with regard to that argument made in the reply, give me one moment. With regard to that argument made in the reply, I'd like to direct the court's attention to the DC Circuit's opinion in the Jankovic case. And so in Jankovic, give me one moment, sorry.
Could I ask you about a case that I'm curious about on this republication issue? Not to preclude you from talking about the Jankovic case, but I'm interested in the Aramo versus Rolling Stone case, which seems to suggest that republication is a question of fact or factual determination, and if so, isn't there a genuine issue of fact here about whether the statements from the former APA members discussing their opinions of the report is a substantive modification, addition, edit that relates to the report?
So Chief Judge Blackburn-Rigsby, if the court doesn't mind, I'd like to defer that to Ms. Wall, who's prepared to testify, who's prepared to address that. If the court really wants me to, I'll take a crack at it, but I won't do as good a job as Ms. Wall.
I'll wait to hear from Ms. Wall on that.
Okay, so I appreciate that, and I'm guessing that Ms. Wall appreciates it too. So yeah, so the citation that I have in mind, again, which addresses something that came up in the reply, is one of the earlier Jankovic cases that the DC Circuit addressed, and it's at 494 F3rd at 1087 to 88. And so this is the question of a republication later by a third party, right? In other words, Sidley issued the report in 2015, and the allegation is APA's website changes in 2018 amounted to a republication for which Sidley should be responsible. So, what the DC Circuit said in the Jankovic case is, at best, the third party reproduction would simply constitute mere continuing impact from past violations that is not actionable as a new cause of action. So their new argument that Sidley should have foreseen this in 2015 doesn't help them say that Sidley was responsible for 2018 website changes, because it's not a new cause of action anyway, and so they fail for that additional reason. So just a couple of things on the Home Rule Act, because again, I don't want to steal Mr. McKay's thunder, but Judge Thompson asked Ms. Forrest, why is the DC Anti-SLAPP Act the most onerous? She identified the test for advocacy on public issues, and all I would just say is the plaintiffs didn't appeal that. So if they're complaining that they're harmed because it's onerous, they didn't even appeal to try to convince this court that the interpretation should be different. Ms. Forrest also says it's the most onerous because there's fee shifting. Fee shifting is a very common element of anti-SLAPP acts all over the country. And it's also very common in District of Columbia statutes. And of course, that's a very premature argument because the parties have agreed that any motions for fees will await the final disposition of the case. So there are plenty of opportunities to challenge fee shifting if it ever becomes an issue. I think the most significant thing that I'd like to focus on, without, again, stealing Mr. McKay's thunder, and I'm sure he'll talk about the Woodruff case, I just want to say that asking, comparing this case to the DC Circuit opinions in Abbas and in Tavi Global Witness, it asks the wrong question. Because, and in fact, Ms. Forrest mentioned the Supreme Court Shady Grove case. That's a case in which the Supreme Court only talks about what does a federal court do when applying its own procedural rules. And it asks the question, or one of the questions it asks is, would applying the state law mean, and comparing it to the federal rules of civil procedure, mean that if you ask a question, you might get two different answers? And that is most assuredly not the test under the Home Rule Act. And I believe it was Judge Thompson who pointed out that there had been, this that in Woodruff, there's a practical, flexible interpretation of the statute. And just one aspect of Woodruff as it relates to the Shady Grove issue is this court in Woodruff said, you can have a legislation from the council, and it could even have an impact on this court's jurisdiction. But the mere fact that it has an impact, it doesn't mean that it's in conflict with Title 11. It just means that it has an impact in a certain class of cases. And then in Mann, this court, disagreeing with the DC Circuit about the interpretation of DC law. In Mann, this court said that the DC Anti-SLAPP Act, it doesn't replace or rewrite Rule 12 or Rule 56. It adds another opportunity in a certain class of cases. But even in those cases, and this is what the court in Mann said, defendant can still file a Rule 56 motion. It's not replaced. This is just an additional mechanism that's added. And I guess, I think finally, Ms. Forrest twice said that I told the Superior Court that the test for our case should be Rule 12 instead of Rule 56. So I'd just like to say two things. The judge disagreed with me, and he applied under Mann the Rule 56 test and gave the plaintiff a significant amount of discovery. Tens of thousands of pages of discovery were provided to the plaintiffs, and they chose not to appeal that. They could have said, you know what, we should have had more. The judge abused his discretion, but they didn't. They decided that they wouldn't appeal that, and certainly as it relates to the merits of this case, they've waived the issue about whether they've got sufficient discovery. But I was making a point that, and this is back in 2019, I was making a point that if a defendant filed an anti-SLAPP motion and said, I'll do it under a Rule 12 standard, which is more friendly to the plaintiff because they only have to show plausibility, that could be filed under the Anti-SLAPP Act. The judge disagreed. The plaintiff got a lot of discovery, put in all these affidavits, and the judge then examined all that evidence and found it was totally wanting. I'll just conclude the point by saying that in American Studies Association v. Bronner, this court ultimately agreed with me and said that there could be a version of an anti-SLAPP motion under Rule 12. Doesn't matter because I lost that point, but that's why I talked about Rule 12. So I believe I'm done unless any member of the panel has any questions for me.
I don't have any additional questions for you, Mr. Hentoff. I don't know if either of my colleagues have any additional questions before we hear from Ms. Wall.
Good afternoon, Your Honors. Barbara Wall on behalf of Applee American Psychological Association. May it please the court. I'm going to start with republication because that seemed to be of interest to the Chief Judge and maybe to others as well. It's worth noting here that republication is a narrow exception to the single publication rule that this court adopted. And it goes back to common law. It's gotten a little more tricky now that the internet makes documents and statements available nearly continuously. But at common law, it had to do with you publish a book and then you publish a second edition. That's republication. The definition has become that republication occurs when a statement is substantively added to or altered with the purpose of directing it to a new audience. Now, Ms. Forrest said it's in the disjunctive. Actually, there are some courts that have phrased it in the disjunctive and some have not. This court has never, to my knowledge, phrased it in that fashion. The closest was the Jankovic case that we just talked about. But the point is that the statement has to be substantively altered in some fashion. And here, the record is unambiguous and undisputed that the report, when it was republished, when changes were made in August 2018, that the report was never substantively changed at all, whatsoever, full stop. Instead, the following things happened. First, you have to understand that the report was on a timeline that had 173 different entries. And it's an extensive timeline. The point of the timeline, and this is the name of it, is Timeline of American Psychological Association Policies and Actions Related to Detainee Welfare and Professional Ethics in the Context of Interrogation and National Security, a mouthful. And there were numerous entries on that timeline. What happened in 2018 as a result of a resolution that passed APA's council was the following changes were made. The landing page was removed. That enabled you to have access to the report by simply going to the landing page. That was eliminated. A letter from APA presidents that was critical of the report was added. A letter critical of the report by APA former ethics committee chairs was added. A statement at the date of February 16th, 2017 was added. The statement said, 5 plaintiffs file a lawsuit against the association arising out of the publication of the independent review. 3, that was the Ohio case that was filed before this case. 3 of those 5 are the appellants here. And that was it. There was nothing else. Unlike the Aramo case, let me be clear on this. These letters, these additions were links. They were not actual reports. They were not actual letters. They were links. And that is critical because every court that has looked at this issue, and there now have been numerous courts, have all said that a link is different than an actual posting, that a link is the equivalent of pointing at or simply referencing a statement. It's not the same thing as remaking the statement itself. And those cases, the cases that have uniformly held that are listed in our brief, but they include the DC Circuit case, Jankovic, that we've been referring to, the Lakhova case in the Fourth Circuit, In Re Philadelphia newspapers, and a bunch of others. In fact, the appellants, plaintiffs, have not been able to point to a case that is held otherwise, where there's simply a link. Here, unlike the Aramo case, the report remained exactly the same. Aramo was different, and to your point, Chief Judge Blackburn-Rigsby, for the following reason. In that instance, Rolling Stone had posted online the article that came under fire. When it became clear that there were problems with the article, they posted what they called an editor's note. And it specifically said right on the article, there are problems with this article. There have been statements that the witness is not speaking truthfully. It is under investigation. That substantively changed the content of the article because it was posted right on there. It went to the jury because the question became, what did this mean at what point? All the other cases that I've just cited have all been cases where courts have made this decision. And you never have to get that. You never have to get there in this case, because there's nothing to, no fact finding that is necessary. The facts, and this is what the trial court found, the facts are clear that the report was never changed. These linked additions are commentary. And it points out another factor, which is APA has acted as a clearinghouse on this point of detainee policies and investigations. And that's what this timeline did, and still does. It's all still posted there where people can look at the various points of view, but the report itself was never republished. As to whether a new audience was achieved, it was on a public website. It continued to be posted on a public website. That never changed. There were two other documents that are addressed in the appellants.
Well, what's the reason for the reposting? Why was it necessary? Can you talk a little bit about that, please?
Sure, with pleasure. In August 2018, there was a meeting, the annual convention of APA's Council of Representatives, which is, excuse me, a large body that is the equivalent of its board of directors. And a resolution by some critics of the report, in fact, some of the affiants, some of the 34 affiants who provided affidavits to the plaintiffs in this case, were the individuals who made this proposal. They proposed that the report would be taken down. They had other proposals related to this. It went to the council. The council voted that down. And instead, what was accepted was these additions to the website. It's simply a function of APA's council.
So they took it down from the quote unquote landing page, which is the main initial website page.
No, they didn't, Your Honor. They just took down the landing page itself. There was no alteration in the report, just the landing page.
Well, maybe I'm misunderstanding what the landing page is. What is the landing page? I was thinking the landing page was the APA's website. when you click on a website, you hit a landing page. That's the initial page of the website, and you can maneuver through the menu bar to different things. And sometimes on the actual landing page are some highlights, key things that the organization or entity wants a web browser to web surfer to look at. And I admittedly, my tech lingo is not expansive, so maybe I completely misunderstood what landing page meant.
No, you're right in this regard. APA's website, apa.org, has a landing site. And when you go on there, you see all kinds of things. The report had a landing page. It didn't, unlike a website's landing page, it didn't have quotes, it didn't have bells and whistles, it didn't have highlighting. It just was a landing page that was removed. Before the August 2018 changes to the website, there were two ways you could access the report. One was it had its landing page. You could type into the APA search box, Sidley report, and it would take you to the landing page. It doesn't do that. That was removed. Instead, only the second way remained. And that was, there's a link to the report on the timeline. That's the only way after August 2018 you could access the report. So in effect,
okay, go ahead, I'm sorry.
In effect, they made it harder to access the report. But again, the report itself remained exactly the same.
Okay.
I believe appellant's brief refers to new members of the APA who would have been expected, I'll use that word, to have access to the website. Your comment was that what was posted continued to be posted on a public website, which I guess means it could be accessed by anyone. So I guess my question is, does it matter that there are some expected new members of the public who will come there because they're new members of the APA, or is that irrelevant?
Well,
or perhaps it goes beyond what the factual record establishes in any event, but is it relevant?
It's relevant only in this regard. From a policy standpoint, well, we back up 1 minute. The courts that have addressed this have all uniformly said that a change in membership of a group doesn't mean that it's directed at a new audience. And from a policy, and there are two cases I can cite to you, the Perlman case and the Lakova case, which was Eastern District of Virginia. Lakova was Fourth Circuit. And the reason for this is a policy reason. Every time a group's membership changes, does that mean you republish the same stale article that's been around since 2015? It's similar to, do you make every time there's a technical change to a website, an advertiser is added or subtracted, every time something is done to the website itself, does that republish the content of the statement? The courts have uniformly said no, because it would be floodgates. There would be no statute of limitations because every website undergoes changes of a technical nature, of a substantive nature when things are added. Those things don't affect the statement itself. And that's sort of a classic definition. The policy purpose, the policy behind making republication a narrow exception to the single publication rule is a very good policy decision. Otherwise, we'd be, every time a website changed, we'd be back in court. There'd be more and more cases that have regenerated themselves as a result of changes to a website that have no substantive change to the statement. And it's
Am I correct in thinking that the significance of this republication issue to the parties is that to the extent that there is evidence after the first publication, and you would say the only publication, but to the extent that there is evidence post that of falsity or evidence that should have caused the defendants to seriously doubt the truth of what the report says, republication kind of gives the plaintiff sort of a second bite at the apple, so to speak. And I don't mean that in a pejorative sense at all, but I just mean that to the extent that there's more information on the side of, see, they should have known, more information out there to support the actual malice claim, republication sort of gathers in all of that additional opportunity to see falsity, and it's important for that reason. Is that the significance to the parties of this? I mean, is that why defendants need to defeat republication and plaintiffs want there to be republication, or they want there to have been republication? Or am I missing the point?
Well, let me answer it this way. Ms. Forrest's statement that republication goes to actual malice, I think in response to a question from you, was nothing they ever argued below, nor have they argued that in their briefing in this case. Not there. In fact, as to actual malice, they had a series of admissions that they say APA engaged in, and then they had 6 different species of circumstantial evidence, none of which holds any water. But in that group, all of their citations for actual malice, they don't say that republication was part of that. Instead, like in the Aramo case, it goes to damages. So there's not a question. If you look at their brief about how they cite or how they refer to actual malice, and remember, actual malice is at the time of publication. What was subjectively in the publisher's mind at the time of publication? You go after the fact and you see, oh, well, in 2018, when the report remained exactly the same, it didn't change anything. So I would submit to you, Your Honor, that whatever their reason for amending the complaint and adding that republication count, I believe that it went to damages as opposed to actual malice, because it hasn't been otherwise. If there are other questions, oh, yes, I did want to say this. I believe one of the first things Ms. Forrest said was something to the effect of there was a substantive addition to the report. I just want to make clear that she may have misspoken, but that is clearly not the case. There's nothing in this record that says there was a substantive addition to the report. I'd like to switch to actual malice, which I sort of dipped a toe into. And the parties have briefed actual malice extensively, both below and obviously in this court. And there was one argument that was never asserted before today. And that was that APA had in its possession the policies, the DOD policies that the appellants say were mischaracterized, misquoted, miscited by Sidley. And if I heard Ms. Forrest properly, she said APA guideline statement number 4, which says, as Mr. Hentoff elaborated, a psychologist should familiarize himself or herself with the local policies. It's a general statement. And then Ms. Forrest leaped from that and she said, Obviously, they needed to know what those policies were. Dr. Caslow, did she put her head in the sand? There is nothing in this record that shows that APA had any of those policies in its possession. When it hired Sidley to conduct the review, it said, and this is in the record, take the investigation wherever you want. It's important to know that the review and the hiring of Sidley was prompted by, and this is again in the record, the book written by a New York Times reporter called Pay Any Price. And this is James Risen, who said APA has been encouraging psychologists to participate in enhanced interrogation. APA had to put a stop to this type of statement. And so it hired Sidley to investigate. Go wherever you want, look at any document you want. We will ask our people to make themselves available to you. Anything in our files you want, you can have. Sidley did its work. And there's nothing in the record that indicates that APA directed it, interfered with it, did anything related to it. It received the report at the end. And the so-called actual malice in APA's mind has never been, certainly to the trial court's viewing or in anybody else's viewing, it's never been elucidated. The publication, who made the decision, that's never been stated by the plaintiffs. There was the APA board, not the council, but the board, and certain members who reviewed the report. And the decision was made to publish the report. The so-called actual malice boils down to 3 affidavits. Well, there are 2 categories, according to plaintiffs. One is that APA made admissions. Its leaders made admissions that they knew the report was false. This boils down to 3 affidavits, one by a recused board member who wasn't in the room and didn't say he heard anything except at a meeting in August 2016, a year after the report was published. A second affidavit by a fellow who wasn't even on, had been the president years before, wasn't in the room, and by plaintiff, Dr. James, who also wasn't in the room. These are not admissions. The affidavits that these individuals submitted were not what is required under Rule 56C4. They did not set out admissible facts that would have been admissible in evidence. Instead, they were statements like, this is both Dr. Resnick and Dr. Anton, the 2 former individuals. I attended a meeting in August 2016, and there were some board members there, and they said some things, and somebody said that there were inaccuracies in the report. These individuals who made the statements were never identified, and whether they were even current board members wasn't identified. And inaccuracies, whether it had to do with any of these plaintiffs, was never identified. This falls very far from actual malice. There's a statement by Dr. James that a board member called him on the phone, and she said, I never thought you did anything wrong, and I hope you didn't feel like I betrayed you. This is also not actual malice. It is that, by the way, the voicemail or the email has never been submitted into evidence. It's double hearsay at best. And what did it mean? That's not knowing publication of something that is false. Then there was an Exhibit B that was attached, which purported to show the connections between the non-recused board members and what activities they engaged in the past. The problem was that they never connected the dots. I'll give you one example that is cited there. There was a statement, I think this is number, statement 29 on Exhibit B, which says that the board hired Sidley. That does not show actual malice by APA's board. There are other statements about APA's lawyer. Ms. Forrest referred to David Ogden hired Sidley. David Ogden did not hire Sidley. He did not authorize anything. He was outside counsel, and his knowledge and Sidley's knowledge actually cannot for actual malice purposes be imputed to APA. Case law is abundantly clear on this. It's a very personal look at the publisher. What did the publisher know? Saint Amant, the Supreme Court case, said, you don't impute any of this. It's what you knew at the time. And the appellants cite a couple of cases that say, well, the lawyer's knowledge, nothing could be closer to a principal and agent and than a lawyer and the client, and therefore you should impute that. They cite two cases. None of them are defamation cases, which is important because a defamation is, as the quote goes, defamation is personal. It's what the publisher knew at the time of publication. And then there are 6 categories of so-called circumstantial evidence that the plaintiffs cite to, only 2 of which actually apply to APA. One is whether APA had bias. So their brief in this case says that, yes, APA had bias because Sidley went over budget. That is not circumstantial evidence of knowing falsity. There's nothing in the record that actually identifies any of that or why that would cause APA to knowingly publish something that was false. And then their only other point about circumstantial evidence is that APA did not retract the statement. As the trial court correctly found, it is the law in the District of Columbia that there is no duty to retract. And there are federal district court cases in the District of Columbia that state that. McFarland versus Sheridan, Fairbanks versus Roller, Lorenz versus Donnelly. There is simply no duty to retract. And the circumstantial evidence is all a bit of a red herring because it's supposed to be able to reflect on what was the publisher's state of mind at the date of publication. There are only 3 types of evidence that the courts have said are circumstantial evidence that are important enough to actually reflect actual malice. And this is in the Saint Amant case. This is in the OAO bank case. And there are only 3 types. One, and they're so far afield from our situation here as to show you why it's grasping at straws, the circumstantial evidence presented here. Only 3 types of circumstantial evidence is found to be persuasive. The statement has been fabricated by the defendant. The statement is the product of the defendant's imagination, or the statement was from a wholly anonymous source. None of those things exist here. In fact, quite the opposite. We have 150 witnesses, people who were interviewed multiple times. Everybody was identified. We have documents on the website, 7,000 documents posted to the APA website, in addition to everything on the timeline and the 541-page report. It's all out there. This is not a case where somebody was guessing about what happened and the publisher, meaning APA, was guessing, didn't know. It received the report as promised. When it hired Sidley, it announced this to the world: we're going to publish this report, and it did. And the world could make up its own mind about the report. Unless you have any questions for me. I could, unfortunately, after 5 years of this case, go on for quite a bit longer, but I think we've hit the issues in this appeal.
All right, thank you, Ms. Wall. We've been very generous with the time, and in fact have blown through all time allocations for each attorneys, in large part because of the number of questions we have. So, Mr. McKay.
May it please the court, I'm James McKay, representing the district to defend the validity of the Anti-SLAPP Act. The paramount purpose of the Home Rule Act is to grant the inhabitants of the district powers of local self-government. To achieve this purpose, Congress broadly provided that the legislative power of the district shall extend to all rightful subjects of legislation within the district. In light of this purpose and this authority, this court has narrowly construed the limitation on the council under section 60284 of the Act with respect to any provision of Title 11 of the DC Code. In several cases, this court has upheld acts of the council in the face of similar challenges, holding that they did not amend Title 11 itself or affect the organization or structure or core functions of the courts. And I mentioned just Woodruff, Hesse, and Bergman as examples. The Anti-SLAPP Act does not amend, and as Judge Thompson said, is not directly contrary to DC Code 11946. The procedure for the Superior Court to amend its rules remains the same, nor does the Act amend or directly contrary to any rules of civil procedure. Rules 12 and 56 remain in place. Instead, the Act creates a specific process to effectuate a statutory right created by the council to protect a public advocacy defendant from the time and expense of discovery and trial if the court finds that the plaintiff's claim or claims are not likely to succeed on the merit. The Act.
Mr.
But
McKay,
counsel-
excuse me for interrupting you, but I just wanted to say, I don't think I said, and if I did, I didn't mean to say that I thought that there was no conflict with 11946. I posed a question about that because it seems to me that it's important to figure out whether there is. So I thought I would clarify that in case it causes you to modify anything that you want to say.
Well, Your Honor, it does not amend any provision of Title 11. It does not amend any rule of civil procedure. It establishes, it effectuates a substantive right by providing procedural protections. And it does that to protect a public advocacy defendant from the time and expense of discovery and trial if the trial court finds a
Well,
plaintiff
11946 says, I don't have the language right in front of me, I should, but it says something to the effect of the Superior Court conducting its operations according to the federal rules of civil procedure, unless it elects to do otherwise, and this court approves that. The anti-SLAPP statute provides for a special motion to dismiss that we have said is an expedited summary judgment motion. And as you know, the federal rules of civil procedure talk about summary judgment motions being filed when discovery has been completed, and the rule describes the movement's burden rather than what the anti-SLAPP statute does, which is to shift the burden to the plaintiff in the suit. So at least arguably, what we have under the anti-SLAPP statute is a summary judgment procedure that departs from the Rule 56 summary judgment procedure without the Superior Court having proposed it and this court having approved it. So that's what I'm interested in exploring, rather than, I certainly haven't concluded that there is no conflict. There may well be. That concerns me. But
Well,
do go on.
Your Honor, Rule 12, Rule 56 remain the same, operational, available to plaintiff and defendant. It creates of the all 32 states have enacted anti-SLAPP acts, have done it by substantive law. None have done it by amending the rules of procedure.
But is there any that has in its Home Rule Act, well, they don't have a Home Rule Act, are there any that have in their constitutions that they are to conduct their business, the courts are to conduct their business according to the federal rules of civil procedure?
Well, no, Your Honor, but the point is that this is a substantive right to protect a public advocacy defendant against abusive litigation. And it's effectuated by giving the defendant certain procedural protections. And this court has said, though, that the fact that an act of the council has an effect on procedure doesn't mean it's outside the council's authority. For example, in this court, in several cases, has upheld acts of the council that have made clearly significant procedural changes. For example, in Woodruff, the court held that the council may make a reasonable determination as to what orders are final for purpose of appeal to this court. In several cases, this court has upheld acts of the council that provided for initial review of contested cases by the Superior Court, rather than this court. The Sullivan v. DC case for the Traffic Adjudication Act, the Price v. Vega case for the Ethics Act, and also I'll add the Escobar v. Department of Health case for the Dangerous Dog Act. All these cases have enacted a legislation that have, certainly as much as the Anti-SLAPP Act, have created differences in procedure. But the fact is, doesn't matter. Yes,
Counsel, I'm following along there, and all those cases you were citing have an administrative overlay, which is a little bit divorced from some of the traditional procedural aspects we would have seen if you were going through a general jurisdiction court. But one of the places I'm struggling with is it seems that the council is perfectly capable of enacting substantive rights, which I can see a substantive right embedded in here, but the Superior Court seems perfectly capable as well of addressing its own rules. We recently approved an administrative order went out with some of the debt protection or consumer protection laws where the Superior Court changed its rules to affect a substantive right that the council passed. How would you differentiate that situation from this one?
Well, Your Honor, the Anti-SLAPP Act that does not really radically change the procedure of the Rule 56. I mean, under Rule 56, the movement can move at any time, and the court can limit discovery. And it doesn't really change. It doesn't really have a very substantial effect on the procedures here. I'm not quite, maybe I should ask you to clarify your question about this other situation. I just wanted to make sure I'm responding to it.
Yeah, so one of the things I was struggling with, and I asked this to appellant's counsel as well, in terms of what they were looking at is, even though I haven't drawn a firm conclusion yet, I can see a substantive right created by this legislation. And I could even analogize it to an affirmative defense that we want early for cost saving purposes, et cetera, to effectuate the legislation. But there definitely appears to be this procedural nexus. And the example I was giving you was where, in response to legislation from City Council providing new substantive rights that would affect procedure, the Superior Court, much in the same way as City Council could delegate authority to an agency to pass regulations to effectuate a principle it put out, the Superior Court changed its own regulations, its own rules to effectuate that, and we approved it and went through the process described in Title 11, the section that we've been dealing with. What I want to know is why that wouldn't be the appropriate course of action that should have happened here, as opposed to the city council dictating the procedure via legislation, potentially in conflict with the section we've been addressing.
Well, Your Honor, I think that the main reason is that the Anti-SLAPP Act does not affect or have an impact on the existing rules of procedure. Now, I mean, the Superior Court might want to do that, but there was no reason to. The Anti-SLAPP Act effectuates a right that the council's created of a public advocacy defendant not to be subject to the time and expense of discovery and trial if the trial court determines that the plaintiff's claim is without merit. I mean, that is a right that would be lost if you did not have the ability or the right of the public advocacy defendant to have the court make that finding or that determination up front. It's a determination, as this court in Mann said, similar to summary judgment, but it is made up front. And if it isn't made up front, the whole purpose of the act would be totally undercut. The substantive right here is protected by a procedural mechanism, but it nevertheless is a substantive right. And there's no other way you could protect this right not to be subject to expensive, lengthy discovery and litigation unless you had a mechanism like that. So the act is self-contained. As I said, it does not require any procedures because it coexists fine with procedures. The act balances competing rights of litigants, and the balancing of competing rights is a quintessential legislative function, and that's what the council did here. I think that the act is looking at all these court's decisions over the last several decades. What the council did here is fairly modest, and it did it for a very specific reason, to protect public advocacy, and it did it in the only way it could protect it, by giving them a procedure to have the trial court make a determination up front under the same standards as summary judgment. You know, a plaintiff or defendant still could move for Rule 12b-6, or they could move for summary judgment. But here you have a specific process that the council has enacted to deal with a specific harm that it has seen as a matter of legislative policy. And it doesn't go any further than it needs to. It is very well balanced act, and it doesn't, it is clearly within the council's broad legislative authority under the Home Rule Act, as this court has interpreted that authority in various cases that are cited in our brief. In other words, we feel that the Anti-SLAPP Act was a proper exercise of the council's broad legislative authority to balance competing rights. I won't say anything about the constitutional arguments other than the fact that you don't have a constitutional right to maintain a cause of action that a court is determined to be without merit. If this court has no other further questions, I'll stop, but I'd be glad to answer any. Okay, thank you.
All right, thank you, Mr. McKay. Ms. Forrest, I believe you reserved a few minutes for rebuttal.
I did reserve a few minutes, but I'm hoping, given what was given to the three other people, that I can go through these briefly. I'm mindful of the fact that although I'm 10:30 here in California, that it's later in DC. I'll move quickly. My pace of my voice is going to pick up a little bit. You will all, as you have done wonderfully throughout, interrupt me.
We'll be very flexible, but we did also give you quite a substantial bit of extra time as well, so.
Understood. I want to deal specifically with the HR, the Home Rule Act first, then go to republication, and then given to public officials, and then actual malice. I'll be as brief as possible, Your Honor. First of all, Mr. McKay represented that courts have all held that anti-SLAPP acts are substantive. That's patently false. California in 2003 and 2006, the California Supreme Court held the California statute is procedural. That's very clear. The only court federal-wise to hold that this doesn't conflict with the federal rules at this point is the First Circuit, the DC Circuit, a case within the Seventh Circuit, the Second Circuit, the Fifth Circuit. All have said, and the 11th Circuit, all have said these sorts of anti-SLAPP statutes conflict. And the DC statute, the DC Circuit, and while you're certainly not bound by that, the DC Circuit has said this conflicts. If you've got a meritless cause of action, what's happened to Rule 11? If this contains any procedures, it modifies. And Mr. McKay was very careful not to say the word modify, but that's the word in 11-946. Judge Thompson, I actually have that language up in front of me. The Superior Court shall conduct its business according to the federal rules of civil procedure. That's the language, not may, shall. This doesn't operate within the rules of federal procedure. It creates two new procedures. That's it. Whether or not a Rule 12 and 56 are still available, irrelevant. This court is the final arbiter of the rules and the procedures that govern the business of the courts. Next, republication. 9 cases cited by defendants simply deal with hyperlinks. That's not what we're dealing here. Ms. Wall represented to you that I haven't cited a single case with respect to republication where a hyperlink
Ms.
or something
Forrest,
more.
Ms.
Yes.
Forrest, I really apologize for interrupting you. And I just beg everyone's indulgence that I just need to take a momentary pause for just about half a minute, and I will go off camera very briefly. I apologize.
Not a problem, Your Honor. Thank you. Too much light now.
Thank you all for your indulgence, but my device was about to die. I was
Oh,
blinking
no.
red here, so I had to get a different charger. Apologies. We
No
didn't
worries.
intend that it would go quite so long today for these 2 cases, so thank you. Ms. Forrest, please continue.
Thank you, Your Honor. 9 cases. So Ms. Wall represented, I hadn't cited a single case that talks about hyperlink or something finding an addition. I point the court to this, to the supplemental authority. The 8th Circuit says all you have to do is hyperlink. Nunes versus Liza, very clear. The defendants cite 9 cases that deal just directly with hyperlink. Jankovic, Saylor, NRA Philadelphia, Stovall, Canatella, Kubala, Mirage, Doctors Data, and Bowling. The defendants cite 3 cases, and I'm going to come back to Aramo, Your Honor, because I want to talk about that case. 3 cases with respect to a new audience. Aramo, Martin was just the website accidentally reappears. That's not the situation here. And Perlman, which was also a hyperlink case. They cite 5 cases which deal with substantive alterations. Perlman, Aramo, Penrose, and Enray Davis and LaRue. We cited Enray Davis, LaRue, a new section, substantive additions to the website or the statements, right? Like in Aramo, and I'm going to come back. They also talk about 4 cases, Sundance, Lakova, and Yeager and Clark. Clark is commercial advertisements. Well, that's not enough, the court says. Yeager, no, it doesn't reference the plaintiff. Sundance, website heading, maybe. Lakova, not republication. But let me be clear, all of these are jury arguments. JA 1815 and 1821 says we reached a new audience. That's it, game over, according to case law. Substantive additions to the website, more like a heading. In Aramo, what you had, they retracted part of it. Here, what you had is after a substantive discussion of the website changes. Look at their own affidavit. They put in 1 affidavit. That doesn't defeat our issues as a matter of law. JA 1078, most of the Fredley affidavit talks about the technical aspects of it. That's not what we're alleging. That's misdirecting the court's attention. What it says is after a substantive discussion to remove the report, they decided to keep it up. This is during Mr. Hoffman being rehired to fix it. They take down 1 landing page, they direct and push out another version of the report on a different landing page, and they reach a new audience. That's all that's necessary. Ms. Wall calls that extensive report that she says at JA 2067.
Ms.
For purposes is a extensive report. Sorry, Your Honor.
That's okay. Can you describe what you mean by the new audience? I guess, as I see it, the new audience would be the APA republishing their report to the American Federation of Prisons, or I'm just pulling an example, making an example up, but they're relocating, I'll use that word, a report that had already been on the same website to the same constituent users and public in a different place. How is that a new audience? I mean, the fact that a different member or a new member joins the same association, which is the audience for the materials posted on the association's website, how does that equal a new audience? I think of a new audience as a new group of constituents, users who hadn't been a part of this APA association or their website or materials.
So, Your Honor, this was new council members. This was exactly their constituents. And the thing about the APA website is they could have published it internally. They have that mechanism. I'm an APA member. I get things confidentially on the APA website that other people don't get all the time. They push this out to the public, and it's still sitting on their website.
It was always pushed out to the public, though.
Right, but it reached new members at a different time. And this was during, and this goes to Judge Thompson's point, and Herbert v. Landau makes it very clear, Supreme Court precedent. If you have evidence in your possession that something's false and you subsequently republish, that is evidence of actual malice. And Ms. Wall's statement that we didn't allege that this was actual malice is belied by our briefs, both below and here. And I'm happy to give the court website references, but we absolutely said in the papers below, and when I get to actual malice, I'll give you the actual page sites. That is evidence of actual malice if you double down. And that's exactly what they did at a time when they rehired him to fix the report. So that's clear. So it's a new audience because new people read it. The single publication rule has never said, we're going to protect libelers who push out a statement a second time intentionally. There was no question this wasn't an accident. And new people read it. That's all that's necessary under the law, Keaton, and all precedent which says under the single publication rule, the only time it's not an issue is if you publish 500 copies of a newspaper on day one, and then day two, you publish something else. We've alleged 10 different republications, each of the counts. And again, these are all jury arguments. And this is what is the problematic with what the court didn't do. We've got 10 publication dates on separate dates. This is a claim by claim motion. Bronner said that. Date of publication, June 27th, Sidley only. June 28th, date of publication, count 2. July 2nd, count 4. Okay, I can keep going. But on each publication date, what did they know? What did each defendant know? APA says it didn't have the documents. That's a jury argument. We showed in our papers below. I'll give you a page number. They absolutely did. Okay, these are all jury arguments. There are 13 causes of action here alleging publications on different dates. They didn't challenge the other publication dates or that sending an email wasn't a republication. What they've done, this one's so important for exactly the reason Judge Thompson identified. And Herbert v. Landau is really clear. They would like to withhold this from the jury. But if you push something out after the fact, it absolutely is evidence of actual malice. I don't think we need it for reasons I'll get to in a moment, but it absolutely is. With respect to Mr. Hentoff's allegation that I didn't allege that this was foreseeable, I would ask the court to go to the complaint 529 to 531. Very clear. It was foreseeable. We absolutely alleged it. And I'll talk to you about actual malice, what we talked about with Sidley. With respect to the extensive document, we're on Zoom, 62 pages. It repeats the defamations. It goes through evidence, chapter and verse, just like in a Rama. I can't think of a more substantive reiteration, which is all that required in the law. Set aside, we also showed a new audience. I understand, Chief Judge Blackburn-Rigsby, you think a new audience is a bigger thing, but we contend we showed, and that's what makes it a jury issue.
I didn't say bigger thing. I said different audience. And I think in my mind, that's a critical distinction here, that the APA website reaches a particular audience, publicly, outward facingly, and internally facing. So, arguably if they republished or reposted or changed the posting and put it on the American Association of Heart Surgeons website, and it reached 2 or 3 new people, that's to me a different audience. But we're still talking about the same platform, the same targeted outreach externally, and the same membership base of constituents. So I guess that was the point that I was making, which is different from the comment you made about 1 or 2 people.
I would argue, Your Honor, that those are jury issues. JA 815, 821 shows that we reached new people and it was read by a new audience. All the arguments you've made are for a jury. This is a matter, this is a factual issue. It's fact-laden. Let me turn to public official. So Mr. Hentoff talked about Thompson. He jumped over Moss and quoted from Rosenblatt. And I'd like to quote, turn this court's attention to Moss v. Stockard. That's this court's precedent. This court's precedent says there needs to be the public's strong interest in robust and unfettered debate and substantial responsibility. It also refers to access to the media, and it also refers to an independent interest. In the 2 pages in defendants' briefs dedicated to public official, they never advance a portion of the test that is required by Rosenblatt at 85 and 86, an independent interest in the qualifications, nor do they address Castle, which involved a VA psychologist, a Veterans Affairs psychologist who was inward facing, much like the plaintiffs here. They don't address any of that. They talk about Dr. Donovan being chief at Walter Reed. Dr. Donovan was chief at Walter Reed with a 10-year time difference. Has nothing to do with her duties in Iraq or Guantanamo. When you leave for the military, you detach and you go to deployment. What her title was at Walter Reed had no impact on what she did to possibly have substantial control or responsibility for policy at Iraq and Guantanamo. The judge conflates them in his opinion, and that's not what paragraph 41 of the complaint says. Mr. Hentoff referred to supervisory roles or how many people they supervise. There's no evidence in there. And like Judge Thompson says, you may treat each of these differently, but that evidence needs to be in the record, and it's not. Turning to actual malice. Couple things. Mr. Hentoff accused me of not quoting the language. I believe that's actually false. And so I will quote again from page 28 of our briefs and my opening. Page 9 of this report. Our investigation determined that APA officials colluded with important DoD officials. Let me bracket here. That collusion was on behalf of a joint enterprise. This is not quoted. 393 sets up the joint enterprise. It was a joint enterprise between APA and DoD. So unbracket. To have APA issue loose, high-level ethical guidelines that did not constrain DoD in any greater fashion than existing DoD interrogation guidelines. JA 2246, page 9 of the report. Existing interrogation guidelines, Mr. Hentoff makes the jury argument now that, oh, that's not what we meant. He refers to a draft book chapter, please replay the videotape, as existing interrogation guidelines for psychologists. That's what we really meant. That's a jury argument. Because existing interrogation guidelines didn't make any distinction. Let me be really clear. When statement 4 of Penn says you're familiar with all applicable rules or regulations, that's everything. It didn't make a distinction between psychologists and everything else. His argument makes no sense. Existing interrogation guidelines, and then he goes on page 12, again to quote, then existing DoD guidance uses high-level concepts and did not prohibit techniques such as stress positions and sleep deprivation. DoD, let me be really clear, never permitted sleep deprivation. That is absolutely and completely false. And to say that we didn't go through this evidence in our papers is absolutely and completely false. J1241, I list the evidence. I list the various reports and why they conflict and whose possession those were in. Page 27 of our brief says they were in APA's and Sidley's possession. J1242. J1243 talks about the standard operating procedures and makes it clear how they conflicted. J1243 talks about the APA listserv and how they conflicted. J1244 talks about the key language in Penn Statement 4 and how it conflicted. J1244 talks about the annotated Penn's guidelines. Statement of Jean Marie Arrigo. He had a tape in his hands that he listened to that said the military psychologists were very clear. They were very clear and very firm. They wanted a standard operating procedure. Mr. Hentoff says, I didn't quote the language. Let's be clear, okay? And I can't show it on the camera, but the headlines. Go to the headlines at JA 5337 and paragraph 37 of our complaint. U.S. tortured doctors could face charges after report alleges post 9/11 collusion. That in and of itself on the defamation by implication gets us back reversed and remanded. JA 1245, information known to the defendants. JA 1247, APA board statement. JA 1248, more board statements. JA 1250, the Martinez-Lopez report. I go through very specifically. JA 1250, the Schlesinger report that had a chart of interrogation techniques. JA 1250, the Senate Armed Services Committee report. JA 1251, the FBI memorandum, twice.
Ms. Forrest,
Yes.
as I understood Mr. Hentoff's one of his points, I didn't understand him to be refuting the volume and number of documents and attachments and that were part of the record in support of your argument. What I understood him to be doing was just contending that they didn't go to the heart of establishing malice. And I'm wondering if you could, given that we are way over time here, kind of summarize the substantive legal argument on supporting the information that these documents that you've just listed, you think highlight for us.
I would love to, Your Honor. Thank you. Competitive enterprise versus man, and this goes in part to Judge Hauer's question. 1258 to 1259, and it talks about Nader, and it talks about man. And here's what man says. In addition to saying bias and some of the other things, and we can certainly talk about actual malice and some of the and bias and all these other things, man says all this comes in, bias does matter, 1259. But here's the heart of it. If you have documents in your possession that show you or knowledge because you were directly involved in the events, and be clear, Dr. Kaslow directed this investigation. We've made that clear in our papers below. It wasn't independent. She arranged for interviews, and she had knowledge because of her involvement in every single event that what was said in the report was wrong. You don't get to stick your head in the sand and then say, oh, he's got great qualifications. And even Marcone, which they cite, says that. And in man, you found four investigative reports. You said that gives you obvious reasons to doubt the truth of what you are saying. And Lorenz has said, you can't investigate and find contradictory information and then say, oh, we didn't know. You cannot rely on somebody if that reliance is unreasonable because you have other knowledge. If you have documents in possession, and I'm not talking about one document in a file drawer, all that evidence I was just listing for you was in both of their possessions. It slapped them in the face time and time again. You've got the restrictive policy with a circle around the date that's handed to them. They say, oh, Mr. Hoffman and Sidley, we were reputable. We had to get it right. I say, you know what? You were too smart and reputable to get it this wrong with so many pieces of evidence in your possession. And that's an argument we should get to make to a jury. If you have obvious reasons to doubt, and that's the language for Mann, very clearly, 1258, 1259, obvious reasons to doubt, that comes out of Saint Amant. You cannot, and some of the supplemental authorities also said this, if you have contrary evidence, especially here, you weren't limited in your time, you weren't limited in your space. And on page 8 of your report, you say you're telling us all the facts. You didn't give us all the facts. You gave us one side of the story, and you tried and convicted my clients in the press, and you didn't even bother. You put in one affidavit on the leak, and then you omit from that affidavit that
Ms. Forrest, I'm gonna encourage you to
Wrap
please,
up?
yes.
Will do, Your Honor. The affidavit that Sidley submitted omits the information that during the time that the report was transmitted to the New York Times, Mr. Hoffman is the only one who had a copy of the report that could have been sent to the New York Times. Even if we're required, and I'm wrapping up, to prove actual malice, we should not have to, because defendants have not met their burden for public officials. But Exhibit A and Exhibit B, which the trial court never analyzed, show that they had very obvious reasons to doubt the truth of what they were saying at each of the 10 publication dates, including when they rehired Mr. Hoffman and republished instead of taking the report down as their members urged them to because of the multitudes of falsehoods. Any contrary arguments should be made to a jury. The judgments below should be reversed and the case remanded for a proper analysis on a claim by claim, defendant by defendant. That's if you don't take out the Home Rule Act, which we believe modifies the rules that every other plaintiff gets in the Superior Court. The case needs to be remanded and reversed. And these plaintiffs need to be allowed to recover for the egregious damage done to their reputations, for being accused of condoning torture when they work their careers to do the opposite. Thank you for your time. I know it's been a long day. We appreciate your questions and your thoughtfulness.
Unless there are any questions from either of my colleagues, I'd like to thank counsel for your briefs and arguments today. And this matter will be taken under advisement.
This court is adjourned.
All right, counsel, you're free to exit our virtual courtroom at this time. Thank you all.